All right. Good evening, and welcome to a special study session, special meeting of the City Council, Thousand Oaks City Council, this Monday evening at 6:30. Would you please join us in the Pledge of Allegiance? Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. And before we are seated, could we please have a moment of silence for all of the victims at the Navy shipyard in Washington, D.C. Thank you. This was the third moment of silence since mid-December, and the second one due to gun violence. Madam Clerk, would you please do the roll call?
Councilmember Irwin?
Here.
Councilmember Price?
Here.
Councilmember Adam?
Here.
Mayor Pro Tem Fox?
Here.
Mayor Bill De La Pena?
Present. Thank you. All right. We do have a public comment section before we would go to our local campaign finance reform study session. And we did have one speaker card available. But that particular speaker will address the issue of the local campaign finance ordinance, and so we will call you when we actually open up the study session. All right. We don't have any public comments at this time. Then I will turn it over to our city attorney, Tracy Noonan, as well as Linda Lawrence, our city clerk, for a joint presentation of proposed changes to our campaign finance ordinance, which was a high goal for the city council back in March when we had our goal setting session. Thank you.
Good evening, council members. I'm going to start off the presentation and start with the purpose of a local campaign ordinance is to eliminate the possibility of appearance of corruption in local elections, keep the elector informed, and inhibit improper or illegal campaign activity, as well as impose different or stricter regulations otherwise governed by state law. The City Council adopted an ordinance back in 1997 requiring disclosures related to local measures. Then in 1998, City Council approved a voluntary spending limit of $25,000 for the November 1998 election. Council also authorized formation of a citizen committee to develop recommendations for a campaign finance ordinance. The committee, in conjunction with legal counsel and staff, met and presented an ordinance for adoption in July of 1998. This ordinance repealed the former regulations and also eliminated the voluntary spending limit. Since adoption of the campaign reform ordinance, minor revisions have been made, including the increase in the contribution limit, which is now set at $380. Additionally, a requirement was added for candidates raising $10,000 or more in contributions to submit bank statements for staff review in conjunction with the campaign disclosure statements. Attachment number 1, starting on page 13 of your packet, is the code as it's currently written. As the mayor mentioned, the review and revision of the local campaign ordinance was identified as a City Council priority at the March 5, 2013 City Council goal setting session. Staff looked at the local campaign ordinances of 138 California cities, as well as the County of Ventura's code. Staff looked at our current code from a user-friendly and practicality point of view, and we're presenting recommended changes for City Council to consider. And we have also outlined some areas that the Council may wish to consider on their own. Once staff receives direction, we'll do further research if necessary and update the code for Council to review at a public hearing. So first we're going to start with some areas under the definitions. And we're recommending deletion or refinement of any definitions that are redundant with state law. Secondly, we're recommending a committee be defined consistent with state law as opposed to the current threshold. So this means raising the threshold from $500 to $1,000 for committees receiving contributions, as well as committees making independent expenditures. Staff's also recommending the major donor committee threshold be raised from $1,100 to the state threshold of $10,000. The typical candidate control committee is going to form a committee. It will meet the state threshold regardless, and the differing local requirement often causes confusion with candidates as they work with their state forms and manuals. The major donor threshold is very low, and due to the contribution limit, can only apply to measures. These contributions are also disclosed by the recipient, and staff recommends this be defined consistent with state law.
If I could just interrupt, what is the state law?
The state law threshold is $10,000.
I think, do you have a question, Mr. Price? Oh, okay.
Next, staff is recommending the addition of a late filing fee for the additional disclosure filings outlined in the ordinance. This includes the third pre-election statement, which applies to candidates only, and the 24-hour late contribution, late independent expenditure filings. This particular filing relates or applies to candidates as well as ballot measure committees. The recommended late filing fee should be consistent with state law, which is currently $10 per day.
The next area for review that the staff is making recommendation for changes pertains to enforcement components of the ordinance. There's 4 enforcement components, and staff is recommending basically a carte blanche change to the ordinance that removes any city staff member with the responsibility to review, audit, investigate, or prosecute any provision of the campaign finance reform. And the reason for that is because of the appearance of conflict of interest. It's really inappropriate for city staff to be investigating and prosecuting either a sitting council member or another candidate who is running for office. It puts them in a no-win situation. Many cities, in fact, have removed the city attorney, the city clerk, and various staff members from performing those types of responsibilities. And in this case, staff is recommending that we do the same, either by hiring an independent consultant or prosecutor that would oversee the entire campaign cycle, or entering into some type of an agreement with the district attorney to enforce criminally the provisions of the ordinance. But in either event, staff is recommending that we remove any requirements from city staff to perform any of the review, audit, investigation, or enforcement components. We've outlined 4 different areas where we have observed this. First one is the assumed name contributions that require the city clerk to investigate the source of contributions. The second section in the ordinance would require for the $10,000 committees meeting the $10,000 contribution threshold. It requires the city to review campaign report forms and bank account statements to verify their accuracy. The third area of the ordinance requires the city clerk, city attorney, or designated representative to investigate and audit campaign records and reports. And the fourth one authorizes the city attorney to prosecute any person for criminal violations of the ordinance. The final area that staff is actually making recommendation for changes pertains to independent expenditure committees. There's been a lot of litigation over these types of committees, what types of limits can be imposed on them. The way that the United States Supreme Court looks at the various committees is they look at committees that are controlled by a candidate, either a candidate committee or a candidate-controlled committee, and then there's all the other types of committees, whether it's a ballot measure committee, a primarily formed committee, or a independent expenditure committee. The Supreme Court has held that the only valid reason to impose any type of contribution limits is to prevent corruption. That's the only legitimate reason to impose any type of campaign finance reform. Leveling the playing field has specifically been rejected by the United States Supreme Court as a legitimate governmental interest that would authorize imposing contribution limits. So that is, we can't look at this campaign finance ordinance with the purpose of leveling the playing field. The only reason we can impose this campaign finance ordinance is to prevent political corruption. The court has held, however, that there is no corrupting influence on committees that are not related to a candidate. So while the courts have authorized cities to impose contribution limits on candidates and controlled candidate committees, courts have struck down ordinances that impose contribution limits on committees that are not related to any candidate. Our code does not make that distinction, and so staff is recommending that our code be revised to make that distinction and make it clear that contribution limits would only apply to candidate committees and candidate control committees, and they would not apply to other ballot measure committees or any other type of independent expenditure committee. Everyone understand that?
Questions? No? Okay.
And I recognize that for 99.9% of the folks that are reviewing and may read this or follow this, this is a very complex and confusing issue. Some of the best attorneys in the state and actually the nation have looked at campaign finance, and to make a long story short, where there's campaign finance, there's a loophole.
There's always,
and that's just a reality that all of they deal with at the national level, certainly at the state level, and local government has found that as well. With that as kind of the preface, clarify a independent expenditure committee that is controlled by the candidate and one that is not, and clarify what is staff recommending.
Well, again, if you have an independent expenditure committee, they're by definition not controlled by a candidate, by definition.
Okay, and so therefore the limit for a contribution is what?
The limit for an independent expenditure committee?
Yes.
Under state and federal law, there's no limitations that can be imposed on those.
I know the answer to these questions,
Okay.
Ms. Noonan.
Okay.
This is for the public's benefit.
Okay, all right, got it.
So an independent expenditure committee, for example, a labor organization.
Yes.
Let's just say the Deputy Sheriff's Association, hypothetically, they can contribute $100,000 to somebody for city council.
They cannot contribute it to that candidacy, but they can contribute and make independent expenditures in support or in opposition to a candidate.
Exactly,
So
I misspoke. They could spend $100,000 on mail or campaign expenditures supporting a candidate for city council or county supervisor.
Yes, as long
as the
it's
candidate does not have knowledge of it.
Right, as long as it's not controlled by the candidate, and the candidate has no say in how those funds are spent.
Right, so that is basically unregulated, unlimited, you can do whatever you want.
That's correct.
All right, and now the contrast between a controlled committee by a candidate.
Controlled committee by a candidate is, again, a type of committee that a candidate has actual control over how to expend those funds. And in that case, the courts have found that the corrupting influence, the governmental interest in preventing corruption applies to those because there is a relationship between that committee and a candidate. And in those circumstances, cities and counties can impose contribution limits.
Okay, very good.
All right.
The remaining items in the staff report pertain to areas of the campaign finance reform ordinance that staff is not making any recommendations. These are either matters that were requested by various council members at the goal setting meeting for staff to look into, or other areas that staff identified that the city council might want to consider.
Mrs. Noonan, if I may interrupt for just a second. I have in front of me the supplemental packet, which outlines in a matrix or table format current language versus proposed language. I think it is much easier to read. And I know that Mrs. Lawrence went through item 1A through 2, and you started off with 3A. If you could just refer to that for
Sure. Absolutely.
For reference
Absolutely.
purposes, I would appreciate that.
We are now going to be on 5. number 5, number 5, contribution limits. Current ordinance right now imposes a contribution limit of $380, but the ordinance itself has an escalator under the CPI based on election. So at this point, it's appropriate for the City Council to either direct staff to bring back an ordinance that raises that contribution limit in compliance with the CPI, or the City Council can consider whether to raise the contribution limits based on some other factor and make revisions to the ordinance under those that direction, or the City Council can consider whether to eliminate contributions entirely. Number 6 pertains to types of contributions. As the city clerk indicated, we reviewed about 138 city ordinances, and there are some that apply, that impose contribution limits on various types of entities. So I've listed a few of them that we have found. For instance, some cities ban or restrict contributions on businesses that have contracts with the city. Some of them impose lower contribution limits for persons or businesses who have applications pending before the City Council. Some cities ban contributions from persons or businesses with contracts of at least $25,000 with the city. And then another example is a city that bans contributions from city contractors whose contracts are actually approved before the City Council. So these are some areas that some cities have imposed various contribution limits or restrictions. There's not a lot of cities that do that, but there are some that do that. A couple things that need to be considered, though, is that in order to do something like this, again, you need to show the compelling government interest in preventing corruption. I will tell you that this issue was actually considered by the City Council in 1999 and 2000 and was not approved to move forward. The other thing to consider also is the practical implications of it. By imposing any of these types of contributions, it would require staff to put together very detailed reports to give to the candidates so they have an idea as to who we contract with, who has businesses pending before the city, and that can be very time consuming. So just from a practical standpoint, you should be aware of that as well. If the council is interested in pursuing any of these types of contribution restrictions, staff would suggest that we add some type of notice provision to either the RFPs or requests for proposals, just so people who want to do business in the city would know that this would, in the future, prevent them from being able to contribute to elections. I'll turn it over to the city clerk for item number 7.
Thank you. The next area is the fundraising time frame. Currently, the fundraising activities can start 6 months prior to the election and needs to wrap up no later than 90 days after the election, and that's just for the purpose of retiring outstanding bills or debt only. Back to Tracy for aggregation.
All right.
Number 8.
The 8th issue is aggregation of contributions. I've worked for various cities, and I can tell you that this is probably one of the most confusing aspects of a campaign finance reform ordinance on how you do aggregation, because a lot of times candidates don't know how an aggregation is done. And by aggregation, what that means is that you're combining contributions and deeming a contribution to come from one entity or one source based on the relationship of various persons or entities or organizations or businesses. In our ordinance, we have a provision in the ordinance that sets forth how contributions are aggregated. Section 1-13.03I of the ordinance presents 5 different ways that aggregation occurs. First one is for entities that share a majority of members on their boards of directors, unless such entities in fact act independently in their decisions to make contributions. The second one is entities which share 2 or more officers. Third one is entities which are in a parent-subsidiary relationship, or where one entity is a branch, division, affiliate, department, or local unit of the other. The next one is an individual or group of individuals and any legal entity or entities in which the individual or group of individuals own greater than 50% of the voting or other stock of the entity, or who receive greater than 50% of the profits of the entity. And the final aggregation component is individual or other legal entities for which the individual is in fact solely responsible for decisions regarding the making of contributions. I reviewed various other cities that have aggregation provisions, and they're very similar to what the City of Thousand Oaks has. I will tell you that the state also has an aggregation regulation, which only has 3 different components. One is that contributions of an entity whose contributions are directly controlled by an individual are aggregated, or if 2 or more entities make contributions that are directed and controlled by a majority of the same persons. And the third is contributions made by entities that are majority owned by any person or aggregated with contributions of the majority owner. A couple of other aggregation provisions I found in other ordinances. For instance, Burbank and the City of Ventura aggregate an individual and any partnership in which the individual is a general partner. And City of Simi Valley allows separating personal funds from the aggregation limit. So for instance, if someone owns a business, they can write a personal check to a candidate, and their business can write a check, and those are not aggregated. It is, like I said, it's a very confusing area of most campaign finance reform ordinances. So council can decide based on your past experience whether you think that the aggregation provisions are clear enough, whether they should be changed, or whether you think that there needs to be a little bit more clarity for that. Ultimately, it is a candidate's responsibility to make sure that he or she complies with the aggregation limits. Back to Linda.
Moving on to Area 9 on the matrix is the additional filing requirements that the city has in addition to state law. If you look on attachment 3, which is on page 27 of your packet, particularly in the month of October, it shows the filing requirements for both the state and local law. The city has a third pre-election statement which covers the period 16 days through the 10th day before the election, and this statement is similar to the other campaign disclosures where the expenditures and contributions are all listed. And then additionally, starting 10 days prior to the election, all the contributions of $100 or more must be disclosed within 24 hours of receipt. This is in addition and a lower threshold than the state law requires, which is a 24-hour disclosure of $1,000 or more. This year, the state law changed. It used to be 16 days prior to the election where the $1,000 threshold, like contribution disclosure, was required, and it's now changed to 90 days prior to the election. So that's always been a confusing point for candidates from my point of view, and I think the 90 days that candidates will be in the mode of the $1,000 limit might help with coming upon the $100 limit time frame. And then also due to the contribution limit for candidates, for the state threshold, it can only be met by personal loans since you're limited to $380 currently for contributions. Area 10 on the matrix is voluntary expenditure limits, and some cities have ranges from a set dollar figure to a dollar figure per resident. Some of those allow a higher contribution limit for those candidates who abide by a voluntary expenditure limit.
All right, item number 11 pertains to loans. Currently, section 1-13.03A4 states that contribution limits do not apply to a candidate's personal funds. Some cities do have maximum personal loan regulations, such as Escondido and Fresno, that impose $100,000 loan limits. State law also has a statute that prohibits personal loans more than $100,000. If that is something that council wants to consider, I would caution you, however, because the U.S. Supreme Court has struck down regulations that place limits on the use of a candidate's personal funds. So I'm not so sure that they are constitutional, but I do note that some cities do have them, if the city is interested. Number 12 is review of campaign disclosure documents. Again, Section 1-13.05B requires city staff to review campaign report forms and bank account statements to verify the accuracy of the reports for committees exceeding $10,000 in contributions. City staff has performed this review for the last several election cycles, and from experience has found very few discrepancies, and none of them, in staff's opinion, were material enough to alter an election and were more likely bookkeeping errors. This review cannot be performed until after the election when all the forms have been submitted in addition. And the review also takes a significant amount of staff time to complete. So in that, based on those practical realities, council can consider whether to continue with this requirement. But as I discussed previously, if council wants to continue with this requirement, staff is recommending that this task be performed by an outside consultant.
The last area is number 13, campaign literature. We found on some of the ordinances, one of the requirement was to actually provide a copy of all campaign literature to the city clerk for public viewing. Currently, we do come across campaign literature that we keep if we have it, but this would require that it be submitted to the city clerk so it could be available for public viewing.
Those are all of the issues that we're asking for council to provide direction to staff. Again, the first 4 items, staff is actually making recommendations for changes, but items 5 through 13 is at city council discretion to make changes, leave alone, or give any type of other direction. Staff is available for questions. We're asking that City Council provide input in order for staff to perform further research if necessary and draft any amended ordinances for consideration and schedule a public hearing for November 5th, 2013.
Thank you, Mrs. Noonan and Mrs. Lawrence. And Mrs. Irwin has a question.
All right, this will be a little complicated to go through, but I first want to say I agree that it would be, having just gone through an election or fairly recently, to have consistency with state law here where you have definitions and filing deadlines and filing requirements. I know that there were 3 candidates, including me, that there was a lot of confusion with our committees between the state and the city deadline. So I would definitely concur with the suggestion that we do things consistently with the state as far as those things are concerned. Limits on the type of contributions, my personal opinion is that this would be extremely labor intensive, and I think probably not constitutional to limit this. We already have full financial disclosure on the website. Anybody that wants to bring up issues about who's contributing to a campaign can I mean, they see all the information. It's right out there. So I don't see that we get into this. It would be extremely difficult. So my first question is, when you talk about enforcement being done by the DA or somebody outside, how does that work? I mean, how much would that cost? Does the DA do it for other cities? I can see that there's a conflict for city staff to do it with council members or for people running against council members, but how would that?
I'm not aware if in Ventura County, if the Ventura County District Attorney has any agreements with any of the cities to enforce it. I know that in other cities and other counties there are agreements between the cities and the District Attorney to do the criminal prosecution. With respect to the non-criminal component of it, whether it's just, again, investigation, performing audits, things of that nature, there are a few cities that the city clerk and I have found that they basically hire either an independent consultant at the beginning of the election cycle, and basically that person is designated to be responsible for anything campaign related. So if there is a complaint that's filed by a citizen, then that independent consultant actually looks at, you know, what the allegations are and does an investigation, and then if there aren't sufficient facts to warrant further review, that time they can refer it over to the district attorney for criminal prosecution.
So, but you're saying in general, and still most city staff are the ones that are
A
responsible.
lot of city staff still perform those review and audit functions. More cities are, see how many have that. There's probably about 25 cities that have an independent enforcement mechanism. Again, whether it's the district attorney, consultant, or special prosecutor, there are law firms and other consultants who specialize in election law who are hired by various cities to perform various tasks. In fact, I think that even in Thousand Oaks some years ago, and it was before my time, so I'm sure one of you can help me out here, there was a time where there was allegations of impropriety and an outside consultant or law firm was hired to perform the investigation and make conclusions, rather than it be done in-house by the city attorney.
Yeah, I have to say, again, going through the election, I got plenty of letters from the city clerk's office saying forms were not exactly filled out correctly. So
and we're not talking about ministerial things, like if a form isn't filled out, if it's missing information, I think that's one thing. But verifying the accuracy of the campaign disclosure forms with bank statements, there's an amount of judgment that goes in that. Determining whether or not there was an intentional violation of the code, because that's the only basis you can bring criminal charges is for an intentional violation. Obviously, there's a lot of prosecutorial discretion that goes in that. There's a lot of requirements and decisions that are imposed on the city clerk, the city attorney, or other city staff that really should be done by an independent consultant. Not only, it protects the candidates, it protects the city council, and also protects city staff from anyone claiming that there's an appearance of conflict.
Okay. But again, that's not done that often. So aggregation also, and a few of us ran into problems with that. You said the state only has 3 requirements. Do you think can you explain kind of have they simplified the requirements? And then maybe if you were also talking about the example of CME, is that more simple than what we have? Because ours is extremely confusing.
The primary difference between SMEs and Thousand Oaks is that it doesn't aggregate, it eliminates an aggregation component between an individual who writes a check from their personal checking account, personal funds, and a business that they own, whereas that doesn't apply here. Regardless of, if Joe the plumber owns a business, regardless of whether Joe writes that check from their checking account or from their business, it's aggregated. So they have the maximum combined contribution of $380. Whereas in SME, Joe could write $380 from his personal checking account and then $380 from his business account. And those are not aggregated. If Joe owns a third business, I don't know, then those funds would be aggregated from the business portion.
But they don't have, what is the limit in CME?
$1,000.
All right, and then...
But if you want to, with respect to the state, there's only 3 aggregation provisions in there, so it is a little bit more simplified. At the end of the day, the aggregation provisions, it will require your campaign treasurer to do some research. Regardless of whether it's 3 items or 5 items, it's always going to require some level of research to determine whether or not the check that this person is receiving is related to any other person or entity that you've already received contributions from. That's the nature of aggregation limits. It's going to require some investigation on behalf of the candidate.
But it could be simplified if we go, if you do the same thing that the state is doing.
Yes.
All right, and then I guess the last question is, did you look at least for the county, what the maximum contributions are?
I'm not sure if you have an updated one. The one that I prepared a couple of years ago had...
I meant not just the county. I'm talking about the cities in the county.
Oh, the cities in the county. Contribution limits of, let's see, $250 in the city of Ventura. Is that what you have? $700 in Ventura County. Those are the ones I have. And then I looked at Burbank, which was $250. Santa Clarita was $360. Simi Valley was $1,000. Not sure if the city clerk has additional.
I just wanted to point out, the county has a
have a
voluntary
voluntary.
expenditure limit, so currently the non-participating candidates is $375 and $750
Okay.
for participating candidates.
All right, thank you.
Mr. Adam?
Yeah, you just mentioned some contribution limits for different cities. I think I heard you say 200, 250. In the staff report, it says here that courts have struck down limits of 200, 250 is too low.
That's correct.
So do you think the ones you just mentioned are at risk?
The one caveat I have with a lot of these ordinances is that there's a lot of ordinances that have been in existence for many years that there's been no challenges to. So, and city councils, tend not to make changes, for whatever reasons. So a lot of the provisions in here, like I said, there's a lot of ordinances that have personal loan limitations, which I question the constitutionality of. What the courts are very clear on, though, is that the contribution limits can't be so low as to prevent the mounting of an effective campaign. And so in one particular instance, a campaign contribution limit of $250 was struck down as not being reasonable. What the courts did say is that that analysis is done on a case-by-case basis, depending on the city that you in. For instance, I would imagine, and I don't think it's very logical, that it takes a lot more money to run a campaign in San Diego than it does in Thousand Oaks. And it probably takes a lot more money in Thousand Oaks to run an effective campaign in Thousand Oaks compared to maybe like, a little town of Half Moon Bay. So courts look at it on an individual basis.
Yeah. And then, like you say, no challenge, no change.
No challenge, a lot of times, no challenge, no change.
Okay, thanks.
A lot of cities have independent expenditure limitations in their ordinances, which are not
Thank you.
constitutional either.
Mr. Fox?
The 750 limit with the county, that's for the supervisors?
Under the voluntary expenditure limit, yes.
I think the distinction needs to be is they run by district. And so as we deal with this, for example, the city of Los Angeles sounds big, but they have 15 council districts. And I can tell you, after having done this for a while, the reality is running for council in Thousand Oaks is a much more difficult proposition in terms of voter to reach the voters, because some of the council districts in Los Angeles, they're getting elected on 7,000, 8,000, 9,000 votes, which all of us have been through enough campaigns to recognize that that's not even close to what we're dealing with in Thousand Oaks. So, and you can look at voter turnout and a variety of things. So I'm just putting out that these things need to be looked at in context to the city that you have, the registered voters, and whether you have districts or you have citywide elections. All those things come into play with respect to what is a reasonable limit or regulation on campaign contributions, because they can be very deceiving. So while the county has 750, they're reaching districts. They're not countywide. Is there a limit for countywide offices? Is it the same or is it higher? Generally, it's higher.
I don't know what it is for like the county clerk.
Yeah. County clerk, sheriff, district attorney.
I believe they're all the same, but I would have to
Okay.
read through.
Any other questions? Mr. Fox?
I just was going to ask of the, I don't believe there's any, but in the county, are there any cities that have districts? None come to mind.
No.
All right. Simi has a limit of 1,000.
Yes,
How long's that been in place?
many years,
Many years.
many years.
They haven't revised it?
Now, when a few years ago, when I was with CME, I took the campaign finance ordinance to the city council for consideration of various changes, and they kept it at $1,000.
Just hypothetically, do you have any idea of the average amount that candidates raise in Simi, having lived there most of your life?
I honestly don't know. But again, it's $1,000, but they don't aggregate personal and business loans, so it was not uncommon for many businesses to give $2,000 in contributions to candidates, one from their personal finances and one from their business finances.
Yeah, I'm just curious if,
Yeah.
they have, campaigns that go in excess of, $50,000, $60,000, $70,000 like we do here.
They do. I can tell you the last election was, just the Police Officers Association, the POA, they spent over $40,000 to promote certain candidates. And the candidates themselves raised much more than that, I think.
That was my question.
Yeah.
All right.
Yeah.
Thank you, Madam Mayor.
All right. Any other questions, Mr. Price? None? Okay. The question that I have is, there are some areas, if we were to go with state law, would actually simplify or perhaps make city ordinance less, our city law, finance law, less strong.
Well,
right now it is, I wouldn't say overly strict, but it's pretty solid. But if we were to comply with state law, it would loosen some of those restrictions, correct?
By loosen, are you talking about like the contributions? The contribution limits, again, I'm not so sure that would like loosen it because there's no contribution limits with respect to the state. But the disclosure and the filing, the third filing, would make changes because those are additional filings and disclosure reports that have to be filed by the candidates that aren't currently required under state law. And that's, Linda provided a calendar so you can see the matrix of how that applies. The other areas that staff is recommending that we revise to be consistent with state law isn't necessarily to loosen the regulations, it's just to make it more consistent so that there's less confusion among the candidates.
And regarding late fees, if the late fee is $10 a day, if somebody, for whatever reason, does not file a late expenditure or a late contribution, and if there is a significant or sizable late contribution, $10, and you wait 30 days to report it, that's only $300. So that's not much of a deterrent, really. I'm actually, I would like to see stiffer penalties for late filings. And if you could speak to that.
Which that could be possible for the local requirement, but not the state.
But not the state, because the state only requires $10 a day.
Correct.
Okay. I would like to call the one speaker that we have before we have any additional questions or comments. Yes? All right, Mr. Kidwai.
I begin in the name of God, who is most beneficial, most merciful, Nick Iqbal Kidwai, resident of Newbury Park, Director Concerned City of Thousand Oaks. I guess there's maybe 4 or maybe 2 people here. I, for the life of me, cannot understand why the need for an urgent meeting, and that too on a Monday. I understand Mr. Fox talked about the residents giving you folks an F. I would like to see that report. If TOTV can show that's the city's webpage. No mention of the meeting. I mean, are you guys purposely trying to make it sure that the citizens are not involved? I have a few suggestions. I've been speaking on this topic since 1997, probably 50 times. And so, in a way, I'm glad that you have it, but 3 minutes is not enough. When there's no public, there should really be no timer. I mean, but Assad would love this, make you heroes. I mean, the kind of way you run the meetings. In fact, right now, the last week's meeting is not even on the, there's no video. It's still not, it shows 5 minutes. So if somebody wants to follow up what happened in Dos Vientos, well, who cares, right? This is just a show anyway. My suggestion is to have a filing fee, because we have too many freeloaders coming in and applying for many reasons, some for publicity for their business, some for knocking other candidates, and when there's no fee, it should hurt a little bit. There's nothing free in this world. And I would suggest that a $500 fee should be asked for, and then maybe it should be applied to the filing fee that the county has for the statement, or something like that. That should be addressed. If TOTV can show that, that's the statement that is with the county. All the statements should be on the website. And you should maybe give additional space to the candidates so that the voters have one place to get there. The other thing, which is completely, since you don't allow enough time to have a cogent argument, is which is not on the agenda, is the un-American Incumbent Protection sign ordinance that you have. For the life of me, the city attorney talks about unconstitutional. It's unconstitutional that I cannot have two signs in my front yard for two candidates unless it's 100 feet. And then how do you measure it? And then this requirement of going to businesses and having the written approval. There were two signs for Mr. Gillette on Teo Boulevard. So I went and talked to the businesses, 7 or 8 businesses. Nobody knew what I was talking about. I called the leasing agent, same thing. You know, I always send emails to the candidates, etc. So it was removed. So I talked to Mr. Gillette. He said that is owned by Mr. Selvin. He owns a lot of properties, and I have green light to put my sign in all of them. This is completely disgusting to limit people's ability to run, because it's inexpensive, and that should really be addressed. Thank you for letting me speak, even though, and you never ask any questions and don't, I mean, it's a sick body, what can I say? Thank you anyway, though.
Thank you, Mr. Kidwai. I gave you a little bit more leeway since you are the only speaker tonight. Thank you. All right, that was it, and I don't know whether, Mr. Adam, yeah.
Mr. Kidwai brought up a filing fee. I believe we do have a filing fee, do we not?
We have a candidate statement fee that's optional for the candidate statement, which is just the printing cost that's passed on from the county for the cost of printing. We have no filing fee like $200 to file or $35 to file paperwork. There's no fee for that, just the candidate statement.
How much was
which
the
is
candidate
optional.
statement fee? I forget.
Typically around $1,000,
Yeah.
give or take.
So in other words, if you want to have your statement on the ballot, which is obviously preferable, if you want to make a run for city council, it's going to cost you $1,000.
Yes.
Okay.
And on that topic, we do post the candidate statements during the public review period on the website, but since some candidates pay for the statements and some don't and don't have one, we have felt in the past that it's inappropriate to have the candidate statement displayed on our website.
I see. Okay, thank you.
Well, Mr. Kidwai does bring up a good point, because we do have every 2 years non-serious candidates, and that is a good point. Would a filing fee be a deterrent for candidates that are not that serious about running for office? Mr. Fox, did you want to make a comment?
Not necessarily on that. I'll get to that. I was going to just start the discussion, since we only had one speaker, and use the matrix. But whenever you're ready to do that, if you want my comment on that, it's if they're not a serious candidate, we shouldn't worry about it.
That is true. Any other questions before we start the discussion regarding these? Mr. Fox, if you want to start off the discussion, are you going to use the matrix and to go starting with
Sure.
point number 1A, and then we can chime in for any questions or comments, okay? Go ahead.
I think your suggestion was a good one. Let me start out, and with the permission of the council, just a few thoughts about what the premise of where I'm at with just my perspective on some of the recommendations from staff. And let me begin with this. On a personal note, I think I and the community are extremely pleased with the conduct of the council. And there is nothing on this piece of paper, there is nothing that we are going to discuss tonight, from my perspective, that should get in the way or disrupt the good business that this council's been doing for this community. Campaign finance has been around for a long time. I recognize that for some cities, this is a hot button issue. I'm relatively optimistic that we can have these discussions this evening and not let it get there. But I want all the council to know that even if we keep status quo, if it's in the interest of conducting what I would consider the business of the city rather than the politics of the city, that's where I'm at. So that's kind of, I say that as a preface to these comments. The second item that I want to discuss is the realities of running for office. All of us, with the exception of Joel, have run for office, and most of us multiple times. Some have been successful, some have not been successful and then been successful, or you wouldn't be sitting here. So the question in my mind is, are we drafting campaign finance ordinance to, in a sense, do what the city attorney has advised and what the Supreme Court has opined and decided, and that is campaign finance should not, and in the case of the Supreme Court, cannot be used to level the playing field. It can only be used to prevent and to try to discourage corruption in public office. From a legal standpoint, I think we're all in agreement for that. I would suggest if we're only interested in corruption in public office, this should be a very short discussion. A very short discussion, because having been here 20 years, having served with virtually a variety of council members, Thousand Oaks is, if not one of, the most business-oriented, corruption-free communities in the entire United States, elected and staff combined. And so that is a short discussion. So I don't think the corruption issue, while the Supreme Court might have opined on that, I think the issue for us is level playing field if we're going to have any meaningful discussion. And that's really the premise and the basis for my comments. The reality of running for public office is if there's campaign finance laws that are too restrictive, I said it many years ago and I'll say it again tonight, it is the Incumbent Protection Act. If campaign finance is so restricted, it makes it very difficult, in my view, virtually impossible for a non-incumbent who is not independently wealthy, i.e. willing to write themselves a check of $70,000, $80,000, $100,000 to get elected, simply because what we all know, their message and their name will not get out to the voters, and therefore the voters have no reason to vote for them, and they're not going to win the election. Even in elections where there's 3 seats up, I think history has told us it is very difficult for a non-incumbent who raises even $20,000 to be competitive. That is the reality. And I think if we are, and I don't believe anybody here is kidding ourselves that while $20,000 sounds like a lot of money, one piece of campaign mail, if done even slightly professional, is in the $15,000 range. I think most people in the general public may not realize that, but it is very expensive to run for office here in Thousand Oaks. And if you see the candidates that have been successful, they either combine campaign funds with another candidate or they raise funds on their own, but all of them are in the $40,000, $50,000, $60,000 range in order to run a competitive campaign where their name and their message is delivered. If we're doing that at $350 a pop maximum, it is very difficult for candidates, particularly non-incumbents, to raise that kind of money. You're talking about 250, 300 contributions. If all your contributions come in at that maximum level, which we all know that's not how they come in. Most of our contributions are in the $25, $50, $100 range. So that 250 number of contributions now goes up to 300, 400, 500, and again it becomes very, very difficult for a non-incumbent to be competitive for a public office. Notwithstanding the fact that I've been elected a number of times, I believe that a person who is not independently wealthy, who is active in our community, who is serving on city boards and commissions, who's active with our youth sports, in our churches, in our synagogues, in civic activities, should be able to be competitive for public office and raise money that if the voters resonate with that message, that person has an opportunity to be elected. I think our current campaign finance laws make that very difficult, if not impossible. So where I'm coming from is, it is leveling the playing field. It's at least making it possible for a non-incumbent who doesn't put in $100,000 of their own money or $50,000 of their family's money to maybe be competitive. And that's kind of where I'm coming from. So with that as the premise, I believe that staff's recommendation to make us consistent with state law makes a lot of sense. And while I don't disagree with some of the comments the mayor's made, I think what we're gaining in consistency, what we're gaining in clarity in being consistent with state law, which most cities are, I think that is a fair trade-off for maybe some of the other more stringent regulations that we may have. I don't see them as game changers, particularly when we're going in the direction at least I'd like to see the council at least consider. With respect, so items 1A, B, and 2, I would say yes, revise those recommendations to be consistent with state law. As it relates to item 3A, that's the whether to hire an independent consultant. I was commenting, who hires that independent consultant? Well, the answer is the city council. Ultimately, if we're hiring a consultant, that will be the city council. That's the 5 of us. Either 3 of us or 2 of us are up for re-election. I kind of question how independent that consultant is when ultimately they're hired by the city council. One could make an argument that there isn't that independence there. So I'm, for one, because of just the practical application of whether that person is independent or not, having done it, we actually hired an independent counsel one election, that we should just allow the FPPC, who is the state regulatory agency, to be the enforcement agency on those campaign issues, and the interested parties can file lawsuits and they can file complaints with the FPPC and not waste the money in an independent consultant, which in my view will be criticized that they're not independent at all. They actually work for the city. So that's my recommendation on 3A, that we let the FPPC and independent parties handle the enforcement. On 3B, same recommendation, the FPPC and independent parties. 3C, same thing. 3D, whether to hire a special prosecutor or let the district attorney. Now, the distinction there for the council is that's for criminal prosecution. I believe the DA is the right person to do that. I know that the DA's office has been reluctant to get involved in political related issues, but I believe that if there was, in fact, criminal wrongdoing, I don't think Mr. Totten's office would hesitate at all to aggressively pursue prosecution in those cases. So I would recommend that the DA handles 3D. Contribution limits. Rather, to clarify that contribution limits, I think that's do not apply to independent expenditure committees. I think we do need to do that. Essentially, it's what the dialogue between Ms. Noonan and myself. If it's an independent expenditure committee, there is no limit. The caveat is they can have no knowledge or they should not be associated with the candidate. And so I believe that that should be yes, we should clarify that. Item 5, contribution limits. I believe our limits are too low. I look at Simi Valley, they have a limit of $1,000. And I think that's at least in a reasonable area where I think the city should consider. I just think that $380, even $400, $500 is just unfair to non-incumbents. And so City of Simi's been doing it for a while. I think that we should seriously consider $1,000. Some would argue we shouldn't have any limits at all. But then I go to what the Supreme Court said, and that is some would argue that as long as you have transparency in reporting, that then it's up to the voter to decide whether there's undue influence. That may be the case, but now we're reliant on our local newspapers and the voters doing their due diligence. And I don't think something as important as that should be left necessarily to those variables. And so I believe that an unlimited number leads us more towards that corrupting influence. But I do believe that a $1,000 limit is reasonable. It's consistent with what's in one of our neighboring communities, which is a light community. Simi is relatively the same size, Relative to the same number of registered voters, same number of people on the city council. While they have an elected mayor, that's the one distinction, but they all run citywide. I think that's a reasonable place to start.
Fox,
Sure.
can we discuss that one right now? Since,
Sure, whatever.
I mean, because this is kind of one of the most salient issues in the
Sure.
whole, and since you're on it, and is that okay?
Absolutely.
All right. Is that all right, Madam Mayor? Yeah, contribution limits. As Mr. Fox says, it takes money to run a campaign. And in Thousand Oaks, it takes a relatively considerable amount to run an effective campaign where you have a chance to be elected. I know the public feels like, well, we want to take money out of politics. We want to take the money influence out of politics. And on the surface, I mean, I agree with that as far as a corrupting influence, but the fact remains that it does take money to run these campaigns. And when you have a campaign limit that's too low, it favors the incumbent.
It does.
There's no question that it favors the incumbent. I can't empirically prove that, but it is incumbent insurance. I mean, look at it this way. An incumbent has a tremendous amount of name recognition. Their names are quoted in the newspaper. Their names are on the ballots. Their names are pictures of us in the hallways. I mean, people know the incumbents. The incumbent has, even with a low level of contribution limit, the incumbent can make up for that in the volume of contributions that he or she gets. So he or she gets 300 contributions, 400, 500, whereas the person who is running because he has the best interest of the community at heart but doesn't have that name recognition may only have 30 or 40 people that he can count on, but he's still stuck with that same low limit. So it's a question of volume of contributions that overcomes the relatively low limit. Yeah, I feel, frankly, that our limit's too low as well. I'm not sure I would go as high as $1,000, and I know CME's had it at $1,000. And maybe it's something that we'll have to debate in November when they bring this thing back to us. But I want to say, I mean, I ran 3 times, and I ran a term limits measure because I firmly believe that everybody should have a chance to hold office in Thousand Oaks. Everybody. And I do believe that by raising the contribution level, it gives the non-incumbent a better chance. So, I mean, I'm thinking maybe 500 would be a number that comes to my mind, but I agree with you in principle that it's too low. I mean, and, you know, if, as it says in the staff report, the contribution level runs from $100 to $2,000, and we're at $380, so we're obviously in the bottom 25% of what the contribution limits are. So I would agree with you in principle there. Let me just go back to one part, Mr. Fox, where you, in 3B, that's that business where the candidate has to come up with the bank account statements to verify their...
But that is actually later. That is item number 12. So we can discuss it at item number 12.
It says 3B here. Current
Yeah.
ordinance requires city to review campaign reports
Yes.
and bank account statements.
Yes, but also if you look at item number 13 on your
Well, I know it's
supplemental,
repeated again.
your supplemental packet, that's
Oh.
where
Okay,
the
all right.
issue of the bank statements is
All right.
directly addressed.
So we're not talking about, you're not talking about that then,
Yeah, actually,
or are
you're
you?
both correct. 3B, I guess my answer to that would be no, because it actually requires city staff to review campaign report forms and bank statements to verify accuracy. Keep in mind, I was the guy that suggested bank accounts should be reviewed.
Okay.
In fact, I'll go as far as to say most of the campaign finance stuff came from me. Okay, and so, but in retrospect, over the years, I think staff's right. It has become very labor intensive. I don't really know what we get out of it. And so my recommendation on that is no, we don't, because obviously the FPPC is not going to look at your bank accounts. They don't do that. And I'm not recommending an interested party. So on that would be no.
Okay. Yeah, I would agree with you there. It's an onerous requirement. It takes a lot of staff time. And frankly, as a candidate, I was a little bit, I don't know what the right word is, that I had to cough up my bank statements to be reviewed. Right. Well, we tried it for a while, and you know, it looks like from what staff's saying is they found very little discrepancies. I think we should eliminate it.
So thank you for that clarification.
Yeah.
So on item 5, I'm certainly open. I just did some quick math, and I would just CME did 1,000, whether we go 500, 750. Again, where I'm coming from, and it's simply where I'm coming from, I know the math of a realistic campaign. And I'm coming from, not from whether this is good for me or the mayor or Mrs. Irwin, people that are established. You're exactly right, Mr. Adams. Incumbents generally do better in terms of fundraising than non-incumbents. It is a fact. So where I'm coming from is the amount of money that is necessary for a non-incumbent to raise and be competitive. Not necessarily they're going to win the campaign, because I think this city, notwithstanding the term limits, has demonstrated a willingness to turn out incumbents if they don't think they're doing a good job. We have a very good history of that. So I don't believe that it's necessarily a guarantee in terms of how much money you raise. We've had candidates in the past that have raised tremendous amounts of money, most through their own personal contribution, and have not been successful. So I don't believe that it's a guarantee, but all of us recognize that hypothetically, if you're going to do 2 pieces of mail, you're going to do a few lawn signs, you want something to put in somebody's hand when you knock on their door, you're talking $40,000 minimum. Minimum. That's no radio, that's no TV, that's no slate mail, that's nothing. And independent expenditures in this city have been relatively few. Relatively few. And I think that's to our credit. Our labor unions don't do it. Most of the public safety does not do it. And the business people have not done it. Historically, independent expenditures, while they have not been completely absent, I think it's fair to say they're not a key factor. And I think that's a good thing. And I think whatever we do, we don't want to encourage that. So that's why I came up with the $1,000. Is it enough? It may not be. We may be coming back and revisiting that. I look at Simi Valley. It's worked with them for a period of time, so that's why I looked at that. Again, not from our standpoint. It's really for a non-incumbent. Item 6, contribution limits impose the same contribution on all persons and businesses. This has come up in the past. I'm not for this. Again, for the record, I don't know that any of us take money from people that have contracts with the city. I think that's a bad practice. I do think that is helpful with campaign disclosure when you make those forms. So whether anybody has a contract with the city for ongoing business, I think it is problematic to enforce that. While I think it's a bad practice, and I would encourage people running for council not to do it, I think making it a law is, again, we get into the enforcement issue. So I'm not in favor of that.
Can I comment on
Sure.
that, please? Yeah, this is very problematic. To me, you're looking at a distinction between disclosure and or restriction. First of all, how do you define who's doing business with the city?
Exactly.
Is it corporations? Is it contractors? Is it attorneys? Is it vendors? Is it nonprofits? Is it they're on my list. Is it the citizens of the city? Is it the presenters at the Civic Arts Plaza? You really could open up a can of worms here. And there's also this business of the staff having to put together an advance notice to people that want to do business. To me, that's a chilling effect. So I want to do some business with the city, and I'm handed a piece of paper saying, well, don't forget, you can't do this, and you can't do that, and you can't do that. It's a chilling effect. I agree with Mr. Fox that it's a bad practice to accept it, I think, personally. But maybe what could be done here, because I know on the 460s, if you were to take a contribution from anybody, you just list the name of the contributor. So suppose it's the XYZ Corporation that does happen to have a contract to the city. Couldn't there be some disclosure there? XYZ Corporation contracted with the city of Thousand Oaks to clarify, because there's the disclosure that people are looking for, but it doesn't necessarily eliminate the ability to give. But then someone reading the 460 could say, okay, and come to their own conclusion.
Are you suggesting that the form be modified where the campaign treasurer indicates that they have a contract with the city, or that staff did the research to determine whether they have a contract with the city?
I don't know. I don't know. That's what we're trying to figure out tonight. I'm just suggesting that, to me, the issue is more not necessarily restricting the ability to contribute, it's the disclosure of it. It's a disclosure of it, and then let the citizenry come to their own conclusion. Okay, so this council member took a contribution from somebody who's contracted to the city. Do I want to vote for him or not based on that? Well, that's up to you.
Yeah, and that's on your campaign finance forms. I mean, you do disclose the name of the business.
Well, yeah, you're right. You're absolutely right. But it'll say XYZ Corporation, but it doesn't say that they're doing business with the city. Someone would have to know that or infer it. Or,
Right.
I'm
And
just
that
saying,
gets
is there
into
some
the-
way to disclose that somewhere in the 460 for then the citizenry to come to their own conclusions? I don't know.
Yeah,
To me,
yeah.
it's a question of disclosure more than it is restriction.
Mrs. Irwin?
I mean, you brought up the problems already with it, and it's the same issue as with the aggregation. Are you going to call every one of your contributors and say, are you putting an addition on a house?
Well,
Are
that's
you,
another problem.
are you
Yeah.
potentially doing business in the city 3 years from now? So I think listing the business, yeah, it is disclosed somewhat, but I think it turns pretty problematic for candidates. And, you know, you're raising a lot of money to call every single candidate and say, is there some possibility that you're doing something with the city, I think is, it's a difficult situation. And then, okay, who enforces that you didn't disclose that? And did you mean to not disclose it?
Yeah.
So that we still have the newspapers that seem to go through those and Mr. Kidwai that go through those candidate statements and tell us exactly what everybody's connection is. But I mean, I understand what you're saying, but I think it's highly problematic.
I mean, I'm throwing it out there rhetorically for just us to consider, but you're absolutely right. I mean, it is definitely difficult to determine just who is contracting the city, and believe me, these campaigns are complicated enough to run. I mean, when this is all said and done, I would like to think that we're going to draft something that's simple and user-friendly that encourages people to run for city council.
And consistent with state law.
We want to make sure that happens,
Right.
yes.
All right, so the 6, it's no, pose different contribution limits. 7 timeframes, I think even more than the limits, this is even more prohibitive for a non-incumbent. To suggest that a non-incumbent has 6 months to raise money for a city council election is, I was against it when it was first imposed by the council. I'm against it now. My view is, in most cities, there is no limit on time. You can raise money. If somebody wants to run for city council and they want to start raising money, 4 years from now, let them do it. I mean, the reality is, it'll be very problematic because generally people are not writing campaign contributions 4 years ahead of time for incumbents or non-incumbents. But I just think this is, I don't see the need for it. I think it's way overly restrictive. And then the question is, well, if it's not 6 months, then what is it? And in my view, I just don't think we need a time limit on it. If we want to have a limit in terms of, financial contribution, okay, we can have that discussion. But my view is there should be no limit on time. If somebody wants to raise money a year and a half before a campaign, good for them. Sure. Ms. Irwin?
Mrs. Irwin?
Yeah, other cities do have limits on time, and the county has limits on time. It's just much more generous than ours. And then I think if you're talking about unlimited time frame, then you are talking about candidate, whether you can have candidate holding accounts. I think, maybe 6 months is too restrictive, but I would like to see a limit on there. I don't want to see that we're in a constant campaign situation. So I would like to see a limit on there, and maybe something consistent with what the county allows.
What's the county? I don't even know. What's the county?
We're looking that up right now.
And they allow holding accounts too.
Yeah, most.
Yeah, I got to agree with Councilmember Irwin, or else we're going to could very well be in campaign mode, year after year after year. I mean, I understand what you're saying. People should have the right to raise funds if they can do it, but I also think to myself that without a restriction, that might favor the incumbent because they've built up this campaign network and they'll be able to go to it. That 6-month business doesn't bother me. I mean, if you want to extend it a little, maybe. And also afterwards, 90 days after the election, Why wouldn't we make that 6 months after? I don't know why.
I don't know.
We would need to restrict it to 90 days. If somebody could raise money after an election where they've presumably lost, and they raise funds to offset those losses, more power to them. I mean, good luck.
It sounds to me, I'm gonna revise that to a year. 6 months to a year.
But what is the account?
She's looking, we're looking at the ordinance right now. So far, we haven't found any limits.
I don't believe the county does, because the county has office holder accounts,
Yeah,
and that would basically nullify limits on when you can do fundraising.
They also have general elections, runoff elections,
Right.
primary.
So I don't believe the county has that limit, because I know the supervisors have office holder accounts, as do most elected officials in the state of California.
So the question would be, if you have if you have no limits, you would have office holder accounts.
Well, the distinction, though, is an office holder account cannot be used to run for election. An office holder account is used by the supervisors to communicate with their constituents. Same thing with Congress, same thing with state assembly members and senators. Now, to just kind of piggyback on what Mr. Adams was saying, there is an inherent advantage to that, because while you're communicating with the residents that, hey, we've lowered water rates, that's a campaign issue. I mean, what I mean by it's a campaign issue, your name is out there, and it's a decided advantage for the incumbents. I will just, full disclosure, that many office holders have that ability. What you can't do is you can't use your office holder account for your actual campaign. So that's the distinction. That's why I put a year. If there's an interest in limiting it, then I think if you do it a year, then you're that would be, I think it doesn't eliminate the opportunity for office holder accounts, but it certainly limits it. But I think it gets it back into the campaign issue in a year. If you can't raise the money in a year, you're probably not going to raise it in 2 years.
You know, you might consider 9 months, and I'm not trying to quibble here, but it would keep you in the same calendar year. See what I'm saying? In other words, the election's 2014, you would start raising money in the year 2014. So it's November minus 9 months, you could start in February. I mean,
I'm good?
Well,
So
let
at least
me
we'd keep in
chime
the
in
same
here,
year.
because I haven't said anything. I was going to wait for Mr. Fox to finish until item number 13, but I have to say I disagree with many of your suggestions. But since we are on item number
7.
I would definitely not change the fundraising and increase it to more than 6 months. It's been working well for the last 40 or 50 years that we've, or ever since this particular campaign finance ordinance was enacted, and I don't see why we need to change it now. There is absolutely no need to change that. I would leave it as is. I've not ever heard anybody ever complain about this, because you don't want, as already stated tonight, you don't want a campaign to drag out for a whole year or more than a year. It is difficult to run a campaign as it is. And now you're going to double the time of running a campaign, and we don't really, I cannot see any candidate, perhaps with the exception of those who have already spoken here on the dais tonight, who wants to increase the amount of campaigning and the effort it takes to run for a seat on the council. And 6 months is a wonderful time frame. You condense everything into 6 months, and everything will be over, and you don't have to worry about it 6 months prior or 6 months after that.
In answer to your question, Councilmember Fox, the county does have a time period, and no candidate can receive any contributions more than 1 year before and 90 days after an election.
well, I suppose staff's going to just have to come back to us with, 6 months, 9 months, 1 year, and we'll have to.
I'm already willing to get off that 1 year and find some consensus. Again, I don't believe 6 months is reasonable for a non-incumbent, and that's where I'm coming from. I'm just going to keep repeating that. If 9 months seems more reasonable, it is in that calendar year. I'm amenable to that. Like I said, I'm coming from this perspective of leveling the playing field. And I believe that 6 months is a very short period of time for a non-incumbent to raise sufficient monies, on top of the fact that he or she has a limit for what they can raise. So if you lengthen the time, maybe you can do something, maybe you don't need $1,000, maybe you can lower it. But I go back to when it's all said and done, if you haven't raised somewhere in the $40,000 to $50,000 range, you're likely not going to be even remotely competitive, let alone win.
Yep.
Now, if you have no incumbents running, well, then that's a different situation. And some point in time down the road, that'll be the case. That will be the case. But for the next 10 years, probably not likely.
Well, let's remember that we all, at one point, were not incumbents,
True.
and this has not harmed us to have a 6-month-long campaign.
Well, just by
not
way
all of us.
we didn't have that.
Four of us.
We didn't have that. That is a fairly recent. That was 1998. Speaking for me, I went through 2 campaigns without that. And there's a whole history on how we got to that I won't bother the council with tonight, but it actually had nothing to do with the campaign. That's not why it was put in. But again, in finding some common ground, if 9 months seems to be amenable, with all due respect to the mayor, I hear what you're saying. It ain't a year, it's not 6 months, it's in the middle. That seems to be, I'm going to revise my recommendation to 9 months, and we'll see where that goes.
Well, I'm sorry, Mr. I can certainly appreciate where the mayor's coming from, because campaigning is a grind, and no one wants to draw it out any longer than we have to. And I think the point that Councilmember Fox is making, if we extend it 3 months, it actually helps the non-incumbents. Am I correct?
Yes.
It gives the
it'll have very
non-incumbents
little
a
impact
chance
on the incumbents.
to build a base. Right. The incumbents don't need any help.
You don't.
But the non-incumbents need a chance to get out there, build a base, and hopefully they could use that extra few months.
I view this extending to 9 months a benefit to the incumbent as well. The incumbent has more time to collect a lot more money. So I'm perfectly content. I'm afraid that we're actually tweaking the campaign ordinance as it is before us a lot more than we probably intended to. I did not think we were going to tinker with the amount of campaigning and raising funds at all. That was never an issue in political campaigning in Thousand Oaks, and extending it is actually, I see it not more beneficial to the non-incumbent, but actually better for the incumbent, because the incumbent has more name recognition. They can raise a lot more money in a longer period of a bigger time frame.
Madam Mayor, if I
Mr. Price.
it's the voice from down at the end of the table here. I appreciate the education I'm getting here tonight, and I couldn't remain silent all night, but I would have to agree with Mr. Fox that 6 months is a short period of time to raise money, and I've watched campaigns form over the last number of years, attended a number of fundraising events myself, and I think that extending it is really giving the opportunity. It's a choice that the candidate could make then. You wouldn't necessarily have to start raising your funds until May, as you do now. By moving that timeline up to 9 months, you have the opportunity to then start raising money shortly after the first of the year. And I would agree. I think it does benefit the non-incumbents, because it gives them a longer period of time to go out and knock on doors and meet and greet people, and perhaps get some money out of their pockets.
Let me explain from my perspective why it helps the non-incumbents, and why arguably the incumbents, it's less of an issue. When you go 6 months from election day, if you're a non-incumbent and you wait till the last month or two of the campaign, because that's how long it took you to raise sufficient money to do a single mail piece, it makes you less competitive than if you were able to raise money earlier on and get a walk piece, get a mail piece, get your name out there early in the campaign season. It is a fundamental reality that without sufficient campaign funds, your name will not get out to the voters, your message will not get out to the voters. It is an inherent advantage to the incumbents, in my view, and it is a huge advantage to the incumbents, because as Mr. Adams has pointed out, I think all of us will, at the end of the day, have to admit name ID is less of an issue for incumbents than it is for non-incumbents. And I think if anybody can up here attest to that, it is Mr. Adam, who went through 3 campaigns. He knows better than most of us that it is a challenge. So by limiting 6 months, it is, in my view, a decided advantage for the incumbents who have less need for name ID, more opportunity to raise funds in a limited period of time, in contrast to a non-incumbent, which fundraising may be difficult, and more importantly, the need to get their name and their message out to the voters early. And so that's why I say, you know, it is important. The 6 months, just in my view, is nowhere near enough time. We can see if 9 months is okay. And by the way, let me just point out to the council, measuring our success here at best will be difficult, because I don't know how we define success. If all of us lose re-election bids, then maybe we did a good thing. Although maybe not, because I tend to believe that we're here because the voters think we're doing a good job. So measurement of success could be problematic. I think what we want to see is competitive council races, not ones that you know going in, it's 2 or 3 people and everybody else simply doesn't have the money. So as the mayor pointed out, they're just not very serious candidates. Not that they're not serious individuals, they're not very competitive. So I'm going to go ahead and amend my suggestion to 9 months.
Yeah, Mrs. Irwin.
Sure.
Yeah, actually, I have a question for the city attorney. I do kind of a process question. We're coming back with this in November. Do we need to decide on all these issues one at a time now, or are you going to come back with something kind of along the lines of what we generally agree on, and then the specifics we'll vote on?
The intent is to come back for first reading of an actual ordinance in November. And the reason why is because we do the first reading in the first meeting of November, and then the second reading, the second meeting in November, then it becomes effective the end of December, beginning of January.
So on the issues that we have questions, we should decide this evening, is what you're saying?
To the extent you can provide, you know, clear direction, we can do that. With respect to other issues, you know, there are still some city council meetings that we can take bits and pieces of it. The reason why we're doing just this as a study session is because there's so much information. It would take, you know, to put it on a regular city council agenda would you know, overshadow everything else going on. But if there's a couple of issues that you need more information on, we're happy to come back, you know, during the city council meetings in the month of October and provide more information to get more direction. But to the extent you can provide clear direction on each of these, that way we can write the ordinance and be ready for a first reading of the ordinance in November. That's our desire.
Okay, so
That's our goal.
So, for instance, about the limits, you would provide us more information, and we could decide that later. But
On the contribution limits?
Let's, for example, yes.
We have a lot of information here. If you need more information, we're happy to provide that. But like the decision on what the contribution limit should be, if it's a matter of deciding and voting on what those limits should be, staff would request that it be done tonight, unless there's actual research that staff needs to do.
Okay, I just wanted to see what the expectations
We do
are
have,
tonight.
thank you. Mr. Price, did you want to say something?
I had a question about the timing of it. Does it need to be, do we need to resolve this issue of the campaign finance reform, if there is to be any, before the end of the year, so that it is in effect at a particular time?
It's generally a goal to have it done prior to an election cycle beginning. Most city councils don't want to do campaign finance reform, make changes to their ordinance during an election cycle, because that can confuse candidates. If, for instance, if you're changing the contribution limits and you're changing the campaign cycle, and let's assume for argument's sake that you allow 9 months, you're going to change it to 9 months now instead of 6 months. That cycle now begins in,
if it's helpful for the council, as I said at the outset of my comments, I'm just going to run through kind of my sense. I don't plan on making the recommendation, the motion on all of these items. I plan on, if it's with the permission of the mayor, going back to one and actually making motions on each item so we can have further discussion. I'm not going to put the council in a situation where it's all or nothing.
That's why I was waiting for you to go through your points before I was going to chime in, but since we were getting into deeper discussion regarding item 7,
Sure.
I thought I wanted to say something regarding that, but I certainly will have input on the other items as well. Mr. Adam.
Okay, so, well, this is a study session. We're in discussion. We're exchanging ideas with the intent of bettering our campaign laws. So it wouldn't in November, I mean, there's two issues that have come up about, one, raising the limits, and there may be some choices there, and two, this business of when you can start raising funds. So would we have to vote on that tonight? I mean, when you want to come back in November and say, okay, here's your choices to raise campaign funds. 6 months, no change, 6 months, 9 months, or a year. And then at that point, we would decide? Or you want us to decide tonight?
You can certainly decide later. The only reason why staff is requesting to be done sooner is because if you do make changes to, for instance, timeframes, and it overlaps into the new election cycle, there's going to be periods of time where the rules apply one way and then they apply a different way if the election cycle is changed. Does that make sense?
Yeah, but I mean, one way or another, we'd have to decide in November.
Right.
I'm just wondering, with the more touchy issues tonight, are we going to have to decide tonight?
The most
for
direction.
example, the campaign limits.
Right. It's ultimately up to the council how
Okay.
much direction they want to give. To the extent you can give that direction tonight, staff would appreciate it. If not, we can certainly come back, but just realize that it would not likely be a first reading.
Yeah. Oh,
Well,
I
a
see what you're
first
saying.
reading would mean, obviously, we were going to enact whatever decisions we're making tonight. And tonight, unfortunately, we don't have hardly anybody from the public here chiming in. It is an off night. It's a Monday night, and I would like for the public to actually be aware of what the changes are that we are proposing prior to the first reading.
Right. The first reading would be a public hearing, of course.
It would be a public hearing,
you
and there
can
might be
make
changes coming
yeah,
to that.
You can make changes that night as well.
Depending on whether we hear from the public or not.
You can. Yeah, you can make changes that night as well.
Okay. All right.
But again,
I tend to agree with
it's
the mayor.
ultimately up to the city council how much direction they want to give staff tonight.
Is it I tend to agree with the mayor. It seems to me that, I know it was covered in the press. I recognize we don't have a lot of folks here, and we got to start somewhere. And that's why I'm, again, emphasizing the council, I'm just throwing out, from my perspective, what I think are reasonable changes. But I do tend to agree with the mayor. Is there something that would prohibit staff? You already have this laid out. Is there some reason this can't come back for a meeting in October and then bring it back for a first reading in November?
We can certainly do that.
Okay. I think that's a good idea. Something as important in terms of a public policy question, I think warrants coming back at least twice, particularly given the fact that we have one or two folks here. Then we have something concrete. Tonight we just had concepts. Really nothing concrete. I think bringing that back for another study session, but with a report that at least reflects the action, whatever action we take tonight, I think that it's a little more transparent.
We can certainly do a department report where during a regular city council meeting and probably include the matrix and add language with respect to direction that was given on each of these
That
to
would be
staff.
helpful.
We can
Okay.
absolutely do that.
I'm
That
going
would
to
be
include that
helpful.
in my motion. However it goes, I'm going to put that at the end of the motion, that we
Okay.
do that. We bring that back.
I think
All right.
that makes sense, and because I was anticipating a discussion tonight. Yeah, I need time to think about this a little bit, and I think Mayor Bill DeLaPena has an excellent point. We would be good to get some public input. So, the press will cover this, and there's been some numbers mentioned here and some parameters, give the public a chance, and hopefully in October they'll come down and we'll see what they think.
Not to mention putting it on the city's website so that the residents can click on it and see the matrix with what is being proposed so that they have an idea. I think this is important that the public should know about this in detail. All right, Mr. Fox, we
Item
were at
8.
item 8. Yeah.
Item 8, I agree with staff. I'm going to say yes. We revise the aggregate to be consistent with state law. Item 9, whether to eliminate the third statement, yes. Again, keeping it consistent with state law. Voluntary expenditure limits, no. Again, I see this as extremely limiting to a non-incumbent. To get somebody to agree to a limit of $20,000, $30,000, you might as well handcuff them. And so, no, I don't think a voluntary limit, while it sounds good, because as Mr. Adam pointed out, I think the public wants less money in campaigns. The reality is if you're going to be competitive and have any chance of election, there is a necessary and realistic amount of money you need to raise in order to communicate your message. And so that would be no on item 10.
I got to agree with that because there's also a question of personal freedom. I mean, are we, as the 5 people here, going to abridge somebody's ability to raise as much money as they want and run a campaign? I don't think that notion is correct.
Right. Item 11, personal loans, whether to impose limits on personal loans, no. I don't think that's constitutional anyway, so that would be no. Item 12, review campaign reports, require city staff to review campaign reports and bank statements, no. I don't believe city staff should do that.
Well, the question is whether to eliminate this, and the review, and the answer would be yes. Eliminate
Yes,
review.
thank you. Yes, thank you. So that's a yes. And then finally, item 13, whether to require all committees to submit copies of all campaign literature to the city for records. Now, is this just committees or is this candidates?
It would be all committees, candidate committees, controlled candidate committees, independent
And what would be the
expenditure
purpose of
committees.
this?
Available for public review, just for it, just to have a library, for lack of a better word, or a
Okay.
file of different campaign literature.
So campaign
It's more for
literature that's
records.
getting mailed to thousands of
Scrapbook.
people okay, let me ask this. Does the clerk just basically take it and put it in the book and it's there for review?
Yes.
All right, then I'm going to say yes on that one. Because that doesn't seem very labor intensive.
I would say no on that one.
Yeah, I would say no as well. It is
Really?
just, yeah, because we're trying to take work away from the city clerk.
Okay.
And
You guys twist my arm.
no, because
Yeah,
the
I mean,
residents are getting the stuff in the mail.
100
I agree.
years
Makes
from
no
now-
sense. Yeah, I was originally going to say no, but okay, that's a no. All right, so
That was easy.
that's items 1 through 13. Madam Mayor, if you'd like, I'll go back to item 1 and we'll just start working our way through it with motions, or how would you want to do
Yeah,
that?
let's have a motion at a time.
All right. So item 1, the definition, I'm moving that we revise it to delete the definition redundant and make it consistent with state law.
I would agree with that.
Me too.
Should we vote?
Okay, so if there are no questions, Mr. Fox is moving that we say yes to item 1A. Please vote.
Motion carries 5-0.
Item
Okay.
1B is the definition of committees, and this is to revise it to make it consistent with state law, and I say we should do that. So that's a yes.
All right,
I'm
and I
moving
would-
yes.
Okay, thank you. And I would like to ask Linda Lawrence or Tracy Noonan if you could, again, explain what the difference would be.
Basically, it's just the threshold for committees receiving contributions like the candidate-controlled committees. The threshold to form a committee, state law is $1,000, and our local ordinance is $500. And the last 3 elections, we've only had 1 candidate that didn't meet the state threshold. The rest would have met the state threshold that were forming committees. The other one is the same scenario for independent expenditures. Our local law is $500, the state is $1,000, and then makes contributions. That's the major donor category. Our current law is $1,100, and the state law is $10,000. And those contributions are also listed on the person who receives the contributions for information.
That's a big difference between 1,100 and 10,000.
It's for purposes of defining what a committee is, because under the
Okay.
campaign finance ordinance, committees are regulated. So if a committee, if you have a committee that takes in $1,000, now they're subject to all of the rules and the regulations. I don't think
Yeah, we seem to have audio problems this evening. I'm not quite sure why. But, all right, so we have a motion that says yes to item 1B, revising the thresholds to be consistent with state law. Any comments or questions? Mr. Price?
I still have a question on C there, 1B, and makes contributions totaling $1,100. We want to raise that to $10,000. And what does that apply to?
what that means, like, for instance, it could never apply, let's say a person wants to donate $1,100 to the to a ballot measure. by virtue of that donation, that person now becomes a committee and is subject to all of the rules and regulations regarding committees. It's already disclosed on the ballot measure committee because they've disclosed that they've received a contribution of $1,100. What staff is recommending is that that threshold be at $10,000, which is consistent with state law, and that's because it's already disclosed by the committee that received the contribution. It could never apply to candidates unless you're going to raise the limit, unless you're going to eliminate campaign contributions for candidates. So it would never apply in that context.
That clears it up for me.
Right. It's just how you define a committee. So a committee could be one person making a contribution of either $1,100 or $10,000. That's really what it boils down to. Does that make sense?
Yes.
All right, then please vote.
Motion carries 5-0.
Item 2 is requires filing deadlines for additional campaign disclosure forms, and that is to clarify whether to impose monetary late filing penalties consistent with state law. And I'm moving that, yes, we should do that.
Okay, and the question for that would be, what do we currently do? What do we charge? I believe it's 0. Is that correct? Please clarify.
There is no monetary penalty for late contributions or late filings for local limits. But I needed to point out, if you do eliminate the third pre-election and the 24-hour disclosure, then it's not necessary to have this fee.
Okay, so...
Well, do we then wait until we get to the other items before we vote on item 2? Let's vote, and let's wait, I should say.
I mean, I'm not a big favor of penalties and fees.
Well, we want to
Yeah.
see how we deal with the other, because I know that the County of Ventura is actually tripling the late fees on some of these late filings to be triple the amount of money contributed, rather than $10 a day.
Yeah, there's no way I'm going to support that. These campaigns are, we all know, they are run with your volunteers. These things are very incumbent. I know I've generally tried to get somebody from the banking industry to do my treasury stuff because it is extremely complex, but that's not an option for a lot of folks. And they're, this is Thousand Oaks. This is a voluntary, essentially, endeavor for most folks. And I think significant penalties, $10 a day, if we want to make it consistent with state law, I'm okay with that. I am not tied at all to penalties for basically a volunteer treasurer trying to help out a neighbor.
Let me clarify. That was, I believe, for independent expenditure committees. When you have large contributions coming in at the last or the 11th hour, that is where the fine, the stiff fine, actually applies, not necessarily to just any
I think
filing.
it applies to both candidate committees and independent expenditure committees.
I thought it was just independent
Is it just
expenditure
independent
committee.
expenditure committees?
Okay, so right now we don't charge anything, but with a change, it would be consistent with state law, which is $10 a day.
I'm amenable to either one.
Well, $10 a day is not that bad.
Again, I'm just trying to be consistent with state law. That's where I'm going.
$10 a day I could live with.
Okay, so my motion is yes.
I'm going to ask the question, if I may.
Yeah, go
Okay.
ahead.
Is there any grace period there? It's a hard and fast rule.
It's
Okay,
not a
just-
hard and fast rule. It's if people are consistently abusing, or if they have a legitimate excuse, we can waive the fine if they request it.
Well, okay, that I like that answer.
So if somebody's
For
had
legitimate
a family
purposes.
emergency or is in the hospital and they can yeah. And Ms. Lawrence, you enforce this if it's not, this is one thing that it's your discretion on whether there's late filing or not?
Yes.
Okay,
Very good. So do we have a motion to...
we do. The motion is yes.
Yes, to be consistent with state law. Please
Yes.
vote.
Motion carries 5-0.
Item 3A is designate the city clerk as the investigating source for contributions. And then the question would be to whether hire independent counsel to perform this task or interested parties. I'm not in favor of an independent counsel and the cost associated with that. I'm not sure really what you get out of that. But I am in favor of allowing interested parties to take whatever remedies that are available to them to enforce state law.
Okay, and that would be the city clerk and/or the FPPC
Yes.
and/or
The courts.
the courts.
So for
leave
clarification, you
as
want to leave
is.
the city clerk in there?
Yeah.
Not the city clerk.
Right. Oh,
The city clerk is out of it. The source of campaign contributions that is a wild goose chase, and I believe that should be left to the professionals, which is the FPPC and/or the courts, if that's the remedy. So I believe that was your
Yes, the
that was your intent
recommendation
with
was
other
to
interested
remove the
parties to
city
enforce.
clerk for a conflict of interest reason. To
Okay,
remove.
so that's,
Right.
my motion
Okay.
is to leave it to other interested parties to enforce.
Well, let me say this. There has to be a complaint filed first by a resident, correct, before anything would be investigated?
Incorrect. It could be another candidate.
Okay, that candidate is a resident.
No, it could be somebody that lives in Cucamonga.
A resident.
Are you saying that if
I'm
you don't
asking-
live in the city of Thousand Oaks, you can't file a complaint?
I believe that's what our ordinance says.
It has to be done by a local resident.
Let us double check.
What the ordinance says, it just says, upon discovery by a candidate or his or her campaign treasurer committee, ballot measure committee, or the city clerk that a contribution has been received in violation of this subsection, the amount received shall be promptly paid to the city. It doesn't indicate that even a complaint is required to enforce that provision. It's if the city clerk becomes aware of a violation of this provision.
Oh, then this one has no teeth at all.
It's again, the concern that I have, and the concern that staff has, it's just not appropriate for the city clerk to be investigating where a source of a contribution comes from. If an interested party, let's say that it doesn't even have to be a resident, calls the campaign treasurer and says, hey, you just accepted this contribution, based on the disclosure forms, and it violates this provision, then the campaign treasurer has a duty to do something about it.
Well, not necessarily. The campaign treasurer could just say, no, you're incorrect, and leave it at that, and nothing will ever come of it.
Well, in that case, if there's any, the general enforcement provisions would apply, and in that case, if it's a civil violation, in other words, not a criminal act requires intent. It's also, an actual intent to violate the law. If it's a civil violation, then any interested party can bring a lawsuit over that.
So we are basically self-police. The candidate is self-policing himself or herself.
Interested parties would be?
But that doesn't say it, interested parties.
No, that would be under the general enforcement provisions. It would, if you're concerned that a campaign treasurer wouldn't report themselves, then interested parties could do it. Under the general enforcement provisions.
Well, that is if the interested party is aware of some sort of omission or impropriety.
Well, if I'm understanding this one correctly, what it requires someone to actually look at the contributions that's received and try to determine whether the contributions actually came from that source. What staff is recommending is to remove staff from having to perform that investigation. If someone lodges a complaint saying that contribution didn't come from X, it came from Y, city staff shouldn't be tasked with performing that investigation against candidates and sitting council members.
Okay, so why would the FPPC then be tasked with enforcing our city ordinance?
The FPPC enforces certain provisions of it. If it's a criminal violation, then again, the recommendation would be that the district attorney look at it. With a lot of this, again, a lot of the cities that we've looked at, it's someone else that does that investigation.
Well, how about establishing a committee, an ethics committee that would be able to review any sort of complaints, whether valid or not?
That's up to the city council. I mean, if that's council wants to establish something like that, that's within your discretion to do so.
Mm-hmm. This way we wouldn't have to worry about hiring anyone or going to the FPPC necessarily, but we still could do that, FPPC. And I mean, the FPPC is just one agency in charge of every city council in California. I mean, they're I can't see them enforcing 400 cities. So it's impossible. We have to take some sort of responsibility here.
Again, the
Ourselves.
concern that staff has is the appearance of a conflict, whether or not it's appropriate to ask city staff members who are employed by the
I
city
understand
to
that,
perform
which is why I'm
Right.
proposing establishing some sort of ethics commission, like I think the county has that. I'm not sure if the other cities have that. That's something that we could do. Mr. Price.
Well, I'm just curious. First of all, if somebody were to file a complaint, what would the city then do? Direct them to the FPPC and or the district attorney's office?
If there's violations of anything that's state law oriented,
Yes.
we refer it to the FPPC.
Okay, and they would be the ones who would determine whether it's civil or criminal in nature?
They could, from the state perspective, yes, because they have civil enforcement alternatives and criminal enforcement alternatives.
And hypothetically, then, they would refer anything that they deem to be criminal in nature to the district attorney's office?
I believe the
Or back-
FPPC also has criminal enforcement
Okay.
capabilities as well.
Other question. I'm not sure that by establishing a ethics commission, I'm not sure that they would have the ability to enforce anything either. I think you'd still be, you'd have recommendations or findings that they would then report to the FPPC, who would conduct the investigation all over again. So I'm just not sure what you accomplish by...
I would imagine the commission members to have legal knowledge of certain things, but it would take away this conflict of interest from city staff.
I guess my point is that they have no authority to take any sort of enforcement action. They can review it, take a look at it, make findings, but there's absolutely no teeth in, and if that's what you're seeking is teeth in our ordinance, I don't think you gain it by establishing an ethics committee.
Well, the ethics commission decision could be binding.
I don't think it
Mrs.
legally
Irwin.
could.
I mean, we've had few incidents where anything like this came up. And Mrs. Irwin.
I just want to be clear. So there's a violation, and the way it has always been done is that you research it, and then you give your information to the FPPC. And so all you're doing is removing the city clerk or the city attorney, and the citizen has to go directly to the FPPC. But regardless of what you do, it ends up at the FPPC because they're the only ones that can do anything. Is that correct?
The FPPC or interested parties can enforce it. Again, from a civil perspective, the way the ordinance is written, the city does not file civil complaints against a candidate for violation of the campaign finance ordinance. Only interested persons will do that.
So there's no point in having the staff looks at it, and really there's nothing they can do about it anyway.
Right. It makes more sense to immediately transfer it to someone else. To do the actual investigation infers that the city is going to come up with some type of conclusion, that there was a violation or there wasn't a violation.
And some sort of penalty, and they can't impose any penalties.
Right. What staff's recommendation is if you want this investigation to be done locally, that be done by an independent party, or if we receive complaints from interested parties that we can transfer it to the FPPC.
I mean, that makes, ultimately, they give the penalties and they do the investigation anyway. So I understand. I mean, I'm getting a little bit more clarity on this. There is no reason to have you involved then.
Right, we can do that, or we can refer it for...
you can pass it along, and that's...
Right, or we can refer it to the district attorney. For local provisions, like for instance, contribution limit, if someone exceeds the contribution limit, it's my understanding the FPPC will not investigate those because that's a local ordinance. So in that case, it would be referred to the district attorney. Or the city council would hire a special prosecutor. Again, it wouldn't be done in-house by the city attorney.
You're referring to criminal cases? Okay. Again, the FPPC is responsible for policing candidates in 400 different cities in California.
Again, for the state provisions,
For the state provisions.
provisions that are consistent with state law, for any local campaign finance ordinance that have nothing related to state. For instance, again, the contribution limits on candidates. There's no state law that limits candidate contributions, so that would be a local enforcement mechanism. So rather than have the city attorney prosecute someone for violation criminally, the recommendation would be that it be either sent to the district attorney or that we hire a special prosecutor for those purposes. Again, there's a big difference between civil and criminal. And there's a difference between what the FPPC will investigate and enforce versus what others can.
Correct. And when you say others, that means others who will file a lawsuit?
You can have interested parties. Again, civilly, interested parties are able to file a lawsuit right now. The city would never do that.
Yeah, yeah.
In the end, it ends up at the FPPC.
Not if...
Or in court.
Or with the district attorney, yeah.
Or court.
Have we been rife with assumed name violations over the years?
I don't think we have. Again, what we're trying to do
I
is
don't
some
recall any.
we're trying to do some cleanup. There were complaints that were filed at the last election, and so what the city clerk and I did was we did refer complaints to either the FPPC or the district attorney because it was inappropriate for city staff to be investigating council members and candidates in an election cycle. So
But
we
in
did
practicality,
for the actual assumed name contribution, I don't know if we've ever received one, but if we're going to eliminate any type of investigation, audit, enforcement responsibility in the other areas, staff is recommending that we make this change in this one as well.
okay.
Okay, my concern is, and again, we have not had, we've hardly had any cases where anything was investigated in all the time that I've been here. They've been very, very few. But if there are no teeth to enforce anything, I don't think it's good policy, nor does it set a good example if we don't show some sort of willingness or responsibility to want to adhere to the ordinance or follow the ordinance. I mean,
The
Mrs. Irwin.
FPPC, you get a letter from them and they give you a fine, so there is enforcement. And they're the only ones that can enforce unless it's criminal. Yeah.
No, I realize that, and I am sensitive to the fact that city staff does not want to get involved, obviously. So that puts you in a very difficult position.
Well,
But I think we need to have, as a back burner, on the option to hire an independent counsel should it be necessary to eliminate that completely. I'm not sure whether that is a good idea. We may never, ever have to hire an independent investigator, and that's only happened once in recent history in Thousand Oaks. So I think that option should always be available no matter what.
I'm not going to support that, and let me simply say that hypothetically you could have 3 council members, which is a majority of the 5 that are up for re-election, and there are complaints against all 3 sitting council members, and they vote no to hire an independent counsel. So just ultimately, I recognize it is frustrating for all of us. The realities are, for local campaigns, we are reduced to, at the end of the day, the FPPC, which is the enforcing agency for the state of California, and the courts for civil issues. For criminal, you have your DA, but all roads at the end of the day lead to the FPPC. I think an independent counsel is problematic because of the political influence that is inherently there. So I don't think you can get around it. So my motion on 3A would be to refer the matter to the FPPC or other interested parties to enforce.
Any comments regarding that motion?
Well, only that,
Mr. Adam?
yeah, there is a perception issue here. I mean, after all, the staff of the city works for the city council, ultimately. If we appointed a prosecutor, that would be picked by the city council. And if we had an ethics commission, they would be appointed by the city council. So it's almost like I'd rather have a third party, and I know the FPPC, is out of the city, but they are relatively responsive. They're easy to get a hold of, and they do know what they're doing. It might take a little bit longer than it might in-house, but to try to judge these things in-house, I think it just creates all kinds of conflicts, perceived conflicts.
Mr. Price?
Yeah, I think aside from removing the city clerk as the person who investigates it, I think we're trying to fix something that is apparently not broken. So I see no reason not to allow the authorities who have influence over these areas to do their jobs. So with that, I'd be in support of that motion.
Okay, any other comments? No? Please vote.
Motion carries 4-1 with Bill Dillapena dissenting.
Thank you.
Okay, items 3B, I'm going to try to bundle these a little bit, if it's okay. Items 3B and 3C deal with essentially city staff delving into bank statements and doing audits of records. I'm moving that we leave that to the FPPC where appropriate or other interested parties.
Can we do 3B separately?
Sure.
Okay.
3B.
Any questions?
Right.
So your motion for 3B would be to, well, who would be reviewing this then?
Basically, I don't believe
For
anybody
campaign
reviews
forms.
bank statements. So,
Yeah, we're not going to do bank statements anymore.
so that would be a no. Just don't do it, just eliminate it. So 3B would be
So
eliminated.
you would just completely eliminate this altogether, contribution review? How long has the clerk been doing contribution reviews?
It's actually a member of the finance department since it was enacted in
And what was 2006? And what was the purpose of reviewing contributions?
Bank records?
comparison of income and
Right.
expenditures.
Oh, to see if there was
See if they balance
hokey-pokey
out.
stuff going on. Okay, all right. Okay, Mrs. Irwin. Oh, no, yeah, go ahead, I'm done.
Okay, so is this saying that the city clerk is not going to review the campaign reports at all anymore?
No, this is just the additional section that was enacted
Okay.
of requiring, once you receive $10,000 in contributions, that you start submitting your bank statements.
Okay, but voting for these, the city clerk is still looking at forms otherwise, right?
Correct.
Okay.
Still doing our state filing officer
Yeah,
requirements.
this is for the $10,000, so if $10,000 contribution is filed and it's not being reviewed anymore and it is being filed late, nobody picks up on that, say, Joe,
No.
this is not what this is.
No, this has to do
Okay.
with the provision in the ordinance that requires that the city review the campaign disclosure forms and the bank statements to verify their accuracy, to verify that the bank accounts reflect how much money's coming in and how much money's going out.
So what is the $10,000 then?
This provision that requires it only applies to committees that raise at least $10,000.
Okay. All right, okay, and Mr. Fox, if you wouldn't mind restating your motion.
Yeah, I'm moving that we eliminate this provision.
Comments, questions? Please vote.
Motion carries 5-0.
Okay, 3C now.
Okay, 3C, again, it puts the city clerk or city attorney and staff in the position of auditing and investigating records to enforce provisions. And my motion is going to be that be performed by the FPPC or other interested parties.
And my question would be, does the FPPC audit, or does the FPPC do audits? Does do, okay, well.
Well, as part of their investigation, I imagine that would be part of their investigation if a complaint is filed by an interested party.
If a complaint is filed, as you said.
That's correct. What the provision says, it's at 1-13.07B. For the specific purpose of enforcing the provisions of this chapter only, the city clerk or the city attorney or their designated representatives may investigate and audit the records and reports of any candidate, candidates control committee, or any other committee that supports or opposes any candidate or candidates for city council or any city measure.
So then it is left to the interested party or parties to do their own investigation, see if anything is iffy, and then they file a complaint with the FPPC?
That's what would happen. Or they can bring a civil action, since most of the forms will be on the city's website under the disclosure rules. Then an interested party can review those forms themselves and then also file a civil lawsuit.
Let me ask you how many times the city clerk or the city attorney or any other staff has reviewed, investigated, and audited records. And we have the auditor here. How many times has that happened? 4 times? In the last how many years? I'm sorry? The last 4 elections? Go ahead, yeah.
The $10,000 committee.
Madam Mayor and Council, we've audited the last, and I want to clarify, we have not audited per se, we've reviewed. An audit actually goes and verifies the source and the numbers, and that would account for a tremendous amount of time. So what we've done is actually compared the expenditures and the cash receipts, those numbers in the bank statements to derive whether most of the money is actually recorded on the disclosure forms. That's the essence of what the purpose of that review was. And that's been done for the last 4 elections, and the differences have been minor. And I'll say 3,000 max, but when you have campaign contributions significantly, in large numbers, it's not material.
Now, of course,
right,
those...
This is for people with over $10,000.
Those 4 elections, as you say, the differences were minor. But perhaps, I'm not sure, I'm just speculating, maybe they were minor because we knew they were going to be reviewed by the internal auditor. I don't know. I mean, I'm just speculating.
If you're looking for a preventative measure, possibly yes, but it seems that most people do try to record all the transactions.
Sure.
The purpose of the whole review really was to determine if everything is getting reported. If someone really wanted to go behind the scenes and spend more money and not report it on their campaign statements and not run it through their bank statements, we wouldn't detect that, as part of this review.
So there is no way then for an interested party to really do a review since no bank statements or anything will be available anymore, correct?
Correct. I mean, you can, the public disclosure forms are available.
Okay, yeah, I think this was the measure that Mr. Fox proposed, correct?
Yeah, the rationale is, and it has not worked, because at the end of the day, if somebody's going to break the law, they're going to break the law. It doesn't really matter what regulation you put in. Like I said, show me campaign finance reform and I'll show you the loophole. It's a very problematic issue. The thought process was, prior to the disclosure of bank statements, all you could review was the FPPC forms that all the candidates fill out. Yeah, 460, and you had no way of knowing if the money that had come in was unbalanced with what the expenditures were, or if in fact the money that was coming in was in fact from the folks that was outlined in your report. You had to take it at face value. So the idea was, if you had bank statements, then you could look at someone's campaign bank account and you could see the deposits coming in, and that should be somewhat consistent. The loophole to that, of course, is when somebody gives their own campaign $10,000, $15,000, $20,000 from their own bank account, their personal bank account, you have no way of knowing where that money came from. So you can just keep going on and on. In an effort to, again, try to have more disclosure, that was the intent. I'm not sure that it really met the mark because, as I've said If somebody's going to violate the law, they're going to violate the law. They're not going to let that get in their way. And in fact, we've been doing it for a while. Staff has seen little or no discrepancies. So I would just suggest that we eliminate it.
Well, I remember it very well. I didn't like the proposal then, and I'll be voting for it to remove it today. So, fine.
All right, so that would be
Thank you.
3C.
3C, yes. So please vote to eliminate, yeah.
Motion carries 5-0.
3D is authorize the city attorney to investigate and prosecute criminal violations. I'm not in favor of that. I'm suggesting that any criminal violations or perceived criminal violations be basically referred to the district attorney's office for criminal prosecution.
That makes sense. Any other questions regarding that or comments? None? Please vote.
Motion carries 5-0.
Okay, and item 4.
Item 4 is the contribution limits as they apply to independent expenditure committees, and the question for the council is whether independent expenditure committees should be clarified from, I guess, campaign committees, correct? And the answer to that is yes.
Yes.
Right, make the distinction to make clear that independent expenditure committees, ballot measure committees, any type of committee that is not controlled by a candidate does not have, the contribution limits don't apply.
Right.
Yeah. Any comments regarding that? None? Please vote.
Motion carries 5-0.
And now we have the meaty number 5.
Item 5, out of the interest, currently our contribution limits are $380. I think that's woefully inadequate particularly for a non-incumbent. Out of the spirit of finding some common ground, I'm going to move that we raise that to $750.
Whoa.
I would just tell the council, I don't think there's a lot of magic to this, and so, whether I think it's high enough or low enough, I think that's certainly a reasoned approach. And we can see in the next election cycle whether again, I don't even know how we're measuring success here, but I heard something about 750. That's what the county has. It's not quite what SEMI is, but it's more than where we are.
I think the city of Ventura is 300, and Oxnard is what, 250? And Oxnard just had...
I don't think Oxnard has contribution limits.
Oh, they don't have any limits?
No.
Oh, unlimited? And there is a brand new non-incumbent who won and spent, I think, $2,000 on her campaign, and she won. $600. She spent $600.
Ventura is $150.
$150 for Ventura. And Ventura is not that much smaller.
Fillmore's $250.
Yeah. So this is something that I would definitely not support. $750 is... I understand it for higher office, higher than the city council, but on a local level, it is Thousand Oaks, and that is money that not everybody will be able to afford. I mean, that is a lot of money to ask from any potential campaign contributor.
Now, this is of the entire thing we're doing tonight, this is one of the most important pieces, and it sure would be nice if we could all agree. Mayor, would you support any increase in the limit?
Well,
I don't mean to put you on the spot.
I'm open to compromise, maybe $400, $450, but $750 is just something that many regular residents are not able to pay. And so this is something that benefits the incumbents and not the non-incumbents necessarily.
I would just point out to the council, I did some quick math. If you want to raise $50,000 and you do it in $75 increments, which is generally, and it just occurred to me, all of us get incumbent and non-incumbent alike, a lot of contributions in the $99 range because of disclosure. So you're looking at well over 500 contributions. And let me just comment on the time period. That's 500 contributions, as we sit here today, in 6 months. That's a little less than 100 contributions a month. Again, I certainly recognize people going to have different perspectives. I don't know how one could argue that is somehow fair to a non-incumbent. It is a tremendous disadvantage to an incumbent when you look at the average contribution. I don't care if you put the contributions up to $2,500. Most of them are going to be in the $100 range, and I'm not suggesting that, but I just think that $400 when we're already at $480, the cost of living. I just don't think that's an incremental approach. That's why I threw $750 out there.
Mrs. Irwin?
Yeah, just one comment about $750. That is what the supervisor limit is, and the total population they serve is very close to the population of Thousand Oaks. So per voter, it's not that outlandish, actually, when you compare to what the county does.
Does everyone agree on the CPI increases?
Yeah, those I thought we did anyway.
We're all good on that, right?
Didn't we
no,
already do CPI?
What I would suggest is...
Well, regardless of what we make the limit, we'll do the CPI increases every other year, right?
No, I would not propose that. I think if we put it at $750, the CPI goes away.
Oh, okay.
Yeah, there's no point in doing that.
Well, that's interesting.
Yeah, it should be $750 and it should stay there until we come back and revisit it.
All right, okay. Well, that puts another wrinkle on it. Well, don't forget, obviously, too, this is a limit. This doesn't mean you have to contribute $750 or $600 or $380. I mean,
correct.
As we all know, my average contribution check is under $100. Under $100.
There are many that are probably under $100. And when I look at the list of names of city candidates who are just average candidates, not necessarily, just regular residents, I don't know where they would get anyone to donate $750.
Well, again, it's, to me, it's the volume at which incumbents can recruit contributions. Speaking for myself, I'm an incumbent now. I wasn't in the number of elections I just ran in. However, I could generate 200 or 300 contributors. Mr. Fox could probably do 400 or 500. I'm not even sure. But Mr. Jones out there, or Mr. Smith, who's never run before, may only be able to do 30 or 40.
Well, Mr. Jones actually came within 1,000 votes of winning a city council seat, and I think he spent $1,500.
Bad choice of names. I didn't mean to single out.
Now, there's another good example of someone who hardly spent any money and came very, very close to winning a seat.
Well, I'm just trying to make the point, if you can only have 30 or 40 contributors, but you could, get $500, $600, $700 for them, it would give you a better chance.
I would argue that the money that Mr. Jones spent in shoe leather more than made up for some of the money he took in.
I was trying to bring up a name, but I'm not an actual person, obviously. I didn't mean Ed Jones. Yeah, thank you. Well, Mayor, again, I really be nice if we could all be unanimous on this, because I think it's very important. It's the most important piece in here. I don't know if it's appropriate to sit here and bargain, but would you consider maybe perhaps a $600 number?
Looking at what other cities in the county are doing, their contributions, with the exception of Oxnard and Simi Valley, are all within a reasonable frame, a reasonable range, anywhere from $150 to $400. As I said, with the exception of Oxnard and Simi Valley. So I don't see any reason to dramatically increase to even double the contribution limits at this point.
Well, 380 to 600
Mrs.
would
Irwin.
be a double, but...
I don't think we're necessarily going to get there tonight with the back and forth, so I would suggest this is one of the things that we have a really clear idea of very current campaign contribution limits. I was under the impression with one of the groups that gave me money that Thousand Oaks was the lowest, because they ended up having to give lower checks to, I think, Moore Park and Simi and Oxnard, because ours was low. So I think Moore Park is higher, but we were talking about maybe coming back with some of it, and I think maybe we should all think about it and just get some additional data.
All right, so
wouldn't mind
for
that.
item 5, let me just continue this item to be brought back. What we would like from staff, because this did not get included in the staff report, is a matrix of cities in Ventura County and what their campaign contribution limits are, if any, and also Ventura County.
So you want all the Ventura cities and the county of Ventura indicate which ones have contribution limits, and of those that do, what the limits are.
Well,
Exactly.
Yes, and I'd also like cities, because, again, we really do need to be realistic. Camarillo is not Thousand Oaks. They just don't have the number of registered voters. And so, I think we do. Simi, in my view, is a very good something to look at, not necessarily because they're $1,000, but they're relatively the same size, relatively the same demographic in terms of male and all that. But I think we need to look at like cities. I don't know
Ventura
that
would be one of
Oxnard is a
Santa
good
Clarita?
example.
Ventura.
Santa Clarita.
Yeah, Oxnard is obviously a lot bigger. They have no limits. So I think we need to look at kind of...
Yeah, we can come up, I thought that this would be available.
The cities in the county, and then maybe 5 like cities. How about
Yeah.
that?
Santa Clarita, Burbank.
It can be
Yeah.
outside of the county. Fresno, I know, some cities with a population
something
of
the same
similar
size,
size.
which maybe they spend the same amount in an election.
Right.
Around.
That would be helpful.
Same governmental structure, no council districts, citywide elections, stuff that, so we're actually looking at relatively close comparisons.
So
Why do
we're
I
not
think this is
voting,
going to
we're
be
not-
something like
No.
the trash?
We're voting to continue this item
Yeah,
and bring it
Solid
back.
waste study.
So no action taken on item number 5.
Right.
Item number 6?
Okay, that's a no, to impose different contribution limits on other business. I just think this is very difficult to enforce, so I'm moving no on that.
Okay, if I may add, it appears that it is difficult to enforce. You mentioned it is bad practice to accept checks or money contributions from businesses which have a contract with the city or have a pending action with the city. I believe city employees are prohibited from contributing to council members.
No, they're not.
They're not? They're not prohibited from... Okay, I thought for some reason that they were not. Oh, they're not. Okay, on there. They can't campaign. Okay.
Right. Employees
Okay.
can't campaign during city hours on behalf
Correct.
of
Okay.
candidates.
But city employees are actually allowed to contribute to council members' candidates' campaigns. Okay.
Yes.
All right. Well, I'm not sure whether it is good practice to accept money from employees, but definitely from vendors that definitely have huge contracts, or any contract really with the city, not necessarily remodeling projects pending in the planning department, but I'm talking about vendors, actual vendors with
Trash haulers, that type.
sizable contracts.
Right.
I think that while it is, we can self-police, but we could say it's up to the individual candidate to accept money. I would agree with Mr. Fox that it is not necessarily good practice to accept contributions, but in order to actually enforce it, as other cities already do, to not accept or not allow contributions from vendors.
If you want to get political about it for a minute, if your practice is to not accept it, and you're running against somebody who is, that's a political statement that the non-acceptor could make,
You can if you choose to.
if you choose to.
I choose to not mention anybody's name in my
Well-
campaign.
Yeah,
so,
I mean, it's
no.
one thing to have the campaign contributions on the
again-
website, but nobody reads
Yeah.
the campaign contributions.
It's in the newspaper states every time there's another disclosure form who the contributors are. It's in the newspaper.
No, not. I mean, yes.
Yes, they do.
sometimes, but not probably. We have 2 newspaper reporters here.
I mean, again, recently having gone through it, every
Yeah.
form that every time we had to, we had a disclosure form, there was a newspaper story the next day, and they listed the 5 most controversial contributors. So I mean, it is in the newspaper, it's on the website, and it's too difficult to police. Yes, maybe it's not a good practice, and we shouldn't do it, but certainly there is full disclosure.
There is full disclosure. The average person does not look it up on the website and doesn't necessarily read the papers. So I just think from an ethical standpoint that we should just prohibit vendors from contributing to any candidate's campaign. Other cities do it already, so as we know. So that's...
Yeah, I'm not going to... my motion's going to stand. I think it's problematic to enforce. Other cities may do it. I'm not sure it's legal because there is free speech rights, and so I'm not sure. But it has not been a problem in Thousand Oaks, to kind of take a page out of Mr. Price's playbook. It's not an issue here. It hasn't been historically. I can think of a few occasions where candidates have taken money, not incumbents. But for the most part, I think as far as the incumbents go, which are the more likely, I think everybody pretty much recognizes that it's a bad practice to do that and then be awarding contracts down the road.
I'm not sure if that is entirely correct.
I don't know.
I don't think it's entirely correct.
Yeah. Anyway, my motion is we shouldn't do it because it's an enforcement nightmare.
Mr. Price?
Well, I'm just going to say that I'd be in agreement with that. I do believe it is an enforcement nightmare. I don't think that it would stand up in court if anybody were to ever challenge it. So for that reason, I see no sense in making a law that is unenforceable.
Okay. If nobody has any questions or comments regarding the motion, I cannot support your motion simply because of past incidents where this has actually happened, and I don't think it's a good idea to do that in terms of accepting contributions from vendors. Please vote.
Well, I just think it's up to the individual candidate, and you know what?
Yeah, no, it is.
And ultimately, the public will judge, and if you decide to take these kind of contributions, and the public may punish you for it. And you're going to have to think about whether or not to do it. But it just, who are these people that aren't allowed to give? And again, I have a list here: corporations, contractors, attorneys, citizens. But there's just be such a huge list. I understand where you're coming from, and I think we all need to be ethical, and we all need to self-police on this kind of thing. But if you decide to take it, I think it's going to come out, and you may ultimately pay for it.
It may or may not. Yeah. Okay.
Madam Mayor, to be clear, I don't disagree with what you're saying. We should not. But I think, and I don't think there's anybody up here that would disagree with you either. But I think the practice of putting in an ordinance to prohibit it is unnecessary and unenforceable.
Well, I'm glad
so I think it's self-policing.
I'm glad philosophically, to some extent, you agree with me in practice. Go ahead, Mrs. Irwin.
Yeah, just one more comment again. And Mr. Adam already went through the list of why it's so difficult to enforce, but certainly taking money from citizens that oppose certain projects, you start to end up in the same sort of situation that it's very difficult to enforce. In some ways, they have, there could be a group of citizens that have a special interest in having some project turned down also. So, it just becomes very problematic. And again, I think there is transparency, and the newspaper covers this. If people don't read the newspaper, then obviously they won't know. But candidates and candidates can use it against other candidates if they think it's an issue.
No, that is true. I think the difference with residents who special interest oppose a certain project or so don't stand to gain financially from the city, so that is something different. But at any rate, if there are no other questions, comments, then please vote.
I guess I do have a question about how was the motion
The motion was to basically not do anything and eliminate this altogether.
The
Number
motion was
6.
to make no changes.
So no
Keep
changes.
the
yeah.
ordinance as is,
Right.
where
Keep it
there's no
as is.
distinction.
We're silent on that right
Yeah.
now. We don't do that. Do we vote? Okay.
I think I may have misvoted there then.
Yeah, just to-
I am in favor of making it no, that's why I asked for clarification on
Yeah.
it.
The
So a
motion,
yes
right-
vote is to make no changes to the
Correct.
existing. Okay,
Yeah.
then I did, in fact, misvote.
Okay.
Change it?
No, we can do that.
You want to
Oh, I
vote,
just did,
you want to
so-
vote yes.
Motion carries 4-1. Mayor Bilda Pena dissenting.
Correct. All right, number
Right,
7.
Item 7, I'm going to, in the interest of both time and finding some common ground, I'm going to ask staff to bring this back again, consistent with the same evaluation you're doing with other cities in the county in terms of time frame.
Okay, so
So
no
that
action
item would be
taken.
continued.
All right. Number 8.
Item 8 is yes, that's to look at clarity and continuity with state law that deals with contributions in the aggregate.
And what is that state law, Madam Clerk, or City Attorney, Mrs. Noonan?
Under state law, let me grab that real fast. There's 3 instances where contributions are aggregated. The first would be contributions of an entity whose contributions are directed or controlled by an individual that would be aggregated with that individual and any other entity whose contributions are directed and controlled by the same individual. So basically 2 businesses. If you own 2 businesses, those contributions will be aggregated. Second one is if 2 or more entities make contributions that are directed and controlled by a majority of the same persons, the contributions of those entities are aggregated. So that would be like limited partnerships, LLCs, and so forth. Third one is contributions made by entities that are majority owned by any person or aggregated with contributions of the majority owner and all other entities majority owned by that person, unless those entities act independently in their decision to make contributions.
Okay, and how is that different from what the city currently has?
City also has aggregation, hold on, let me pull that up real fast. Entities which share 2 or more officers, entities which are in a parent subsidiary relationship or where one entity is a branch, division, affiliate, department, or local unit of the other. The 50% one is already in the state one. Individual or other legal entity for which the individual is in fact solely responsible for decisions regarding the making of contributions. So those would be the
Okay, so this is the work of the Blue Ribbon Committee in 1998, I believe, that came up with this, correct?
I don't recall.
Yes, it was the work with the outside attorney.
Yeah, I hate to undo the work that was already done by many of our residents, even though it was a long time ago. I still think that we should probably keep it in place as is.
Wasn't it suggested that you'd come back to us with some new language? I don't really get either one, to be honest with you. If I was a new candidate reading this, I'd be like, what?
They are confusing. If you'd like, I can come back with a matrix and I can try to come up with some examples if that would help.
Yeah, some everyday common speak language.
All right, so item 8, I'm going to revise my motion, and that should be continued and be brought back with
Okay,
some clarity.
Sounds
That would be
good.
good. I appreciate that.
Okay.
Number 9.
Item 9, the requires a third pre-election campaign disclosure. I'm moving that we eliminate that, making consistent with state law.
And again, I ask for the difference, Mrs. Noonan, between the two.
This is an additional statement after the second pre-election required by the state. Yes, it's on the calendar.
October 6th?
The third pre-election covers October 19th through October 25th in 2014.
And if we were to be consistent with state law, the last one would be on October 25th rather than the 28th?
The second pre-election would cover October 1st through October 18th,
Mm-hmm.
and it's due on October 23rd.
October 23rd, okay. And then there would be nothing after that?
Only the late independent expenditures until the semi-annual at the end of December.
Say that again? The late expenditures until when?
You would have the state late independent expenditure and contributions in effect. That's the $1,000 within 24 hours. And then the next report covering from October 19th through December 31st would be due the end of January.
So the third statement is due when?
It is due on October 28th, and it covers October 19th through October 25th.
But the state still requires it at 1,000 level.
Correct.
So it's the only difference would be you would still, every time there's 1,000, you would still have to file a statement. It's just
Within 24 hours.
within 24 hours is what the state says, and the city says that within 24 hours you have to file at what level?
Currently at 100.
So, I mean, it seems that the big issue would be you would want to know if there's a lot of money flowing in at the last minute. For $100, I'm not sure that we care that much. So to be, I agree. I don't think you lose much by being consistent with the state, and it's much simpler for candidates to have that consistency.
And it's aggregate, right? So it would be more than $1,000, because right now you can't get a $1,000 contribution anyway.
Right, personal loans for candidates, pretty much.
Okay.
But when you say aggregate, so if you get contributions that total more than $1,000, you don't have to report those? If they're all if they're all under 1,000?
No, they'd be under 380 right now.
Right. We have the contribution limit at 380, so you're not reporting anything over $1,000 unless it's a personal loan that's not restricted.
And it covers the period through October 25th.
23rd, the 18th.
It says 1019 to 1025?
Oh, that's the third one?
Yeah.
Yeah.
So the motion to eliminate means actually to just be consistent with state law, which will require it on the 28th as well, for $1,000?
Yes, the $1,000 would fall under the late contribution reporting within 24 hours per person.
After the 28th, or after the 25th?
Which we don't have.
I know.
So, basically what you're gaining in the third disclosure, one, you're gaining disclosure, which is a good thing. But I think it's been pointed out, you're looking at contributions of, a $200, $100 contribution, even if you got, 10 of those. I don't know that it really is. There's a real value in the staff time to deal with that.
No, maybe not staff time, but it is of value to any sort of, for any candidate running.
Well, it's your treasurer's doing the report. I mean, the purpose of disclosure is so the public can see who's giving you money when and how much.
Yes, and historically, not in the city of Thousand Oaks, but politically, usually, we've seen in other areas where there's literature coming out at the 11th hour that is funded, and I think this is for transparency purposes. I don't know if it's happened here in Thousand Oaks. I don't recall, but this is to inform and to disclose and have transparency if there is late literature coming out that it is disclosed and that there is money
That would be
coming in.
covered.
Because it's $1,000.
That's over $1,000, which you're not sending anything out for $1,000, and that's coming from a independent expenditure.
Just for clarification, I think you asked whether those contributions are aggregated under state law, and I don't believe they are. So if you received 4 $250 contributions under state law, the late filing, you would not need to do that.
Right.
Okay, I just want to make sure everyone's clear on that. You would not. Only if a contribution exceeds $1,000. So in that case, the only time it would apply for the city of Thousand Oaks would be if it's a personal loan.
I'm not caught on this one way or the other. If council wants to continue the practice, I don't see the real value of it. The narrative Ms. Builder's opinion talked about, that is covered. You know, the last minute hit piece type thing, that's got to be disclosed because that's over $1,000.
But how much, tell me the date, when do you have to stop filing? What is the date? 25th?
If you look at page 27 of the staff report, I don't know if you have the calendar in front of you. It's on page 27 of the staff report. It's the October calendar. Is it the October?
I'm looking at this, at the calendar here, and that October 28th report would report for the period covering 10/19 to 10/25.
Correct.
So assuming that you were to file on a 10/28 and you were an opposing candidate, I think it's a little late in the game to do anything about it anyway. Talking about a week before the election.
Is it a week? It's a week before the
Yeah,
election?
it's a week before the election.
Yeah, I don't have
A
the...
little bit more.
It's due the week before the election, prior Tuesday.
I actually, I agree with the mayor. I think that we should keep that one in.
I mean, for us running campaigns, yes, it's you know, we're not thrilled to be filing another statement, but I think just for transparency reasons, I think it's important to have that.
But we do
What's
have
the
two
pleasure of the
layers
council on
here.
this?
and
I'm not interested in a big split vote on this. If everybody's, I'm good.
Could we put this one off until later?
Let me ask, could it be aggregate? Because that full week, if you're ending up with a big fundraising thing and a whole bunch of checks, you could end up with...
$10,000.
Yeah, so I guess, I mean...
I'm just saying, hypothetically, you could get
you could.
10 checks of $250.
Right before the deadline. So I'm
Yeah.
just... Yeah, maybe we can check with it because I don't...
Or actually, you could get 2 checks of $380. If we stay at $380, you could get 20 checks. I mean, is
Could you
it
just-
realistic? No, but...
Would you just be able to clarify it via the calendar a little bit? I mean, no, I'm saying just come back
back?
with it
Okay.
because exactly what it means.
Sure.
Well, yeah, at this point, I don't see why we needed to change that. I feel like we've tinkered with campaign finance already so much that I'd like to see some of these provisions remain as they were and had been intended by the Blue Ribbon Committee, which was convened so long ago. I really don't want to undo most of it because it didn't hurt anybody, really. If anything, it provided more transparency, item number 9.
Do you want to bring it back, or you guys want
Do you
to
want to
move
bring it
forward on
back?
this thing? It's not going to change in a month, but
I don't need to have it brought back.
Well, I'm just not clear on the whole aggregate thing. I don't
mind.
How do you have to do it? It's every time you have one contribution now, you have to file.
Under state law, what we're referring to is state law. If you eliminate the third pre-election campaign disclosure statement, under state law, you still have the late independent expenditure disclosure forms, right?
Or anything over 1,000.
And that only applies to contributions over $1,000, and that's not aggregated under state law.
No.
So if you receive a $380 contribution under state law, you would not have to disclose it under that.
Correct. And if you get 10 of them or 20 of them, you still don't have to disclose it.
That's correct.
And you have it's
Until after
correct.
the election. But
and
then
it's
too
and
late.
it's in the last 7 days.
It's ironic that the 5 of us who are all seasoned politicians can't figure this out. Here at the dais, we're having trouble
mean,
with
you
it.
can turn
Think what the
around-
guy who's just decided to run might be. I mean, if the idea is to simplify this thing, I mean, yeah, I mean, I can support it the way it is, I guess, but it seems to me we got two sets of laws here. Why not just go with the state and keep
But-
it simple?
So is it just tell me if it's only 7 days, then Mr. Price is right. You can't. It's probably
Price
a little
is
bit.
right.
The price is right. I had never said it
Okay, to
before.
confuse you even more, because I know you have such a, okay, If you eliminate the third pre-election campaign disclosure form, if you look at your calendar, the last state-required pre-election campaign disclosure statement is due October 23rd, and that covers up to October 18th. So that would be the last form, except for under what state law requires, disclosing contributions of $1,000, okay? That would be the last one. But you also have your local late independent expenditure contribution reporting, which is 24 hours of $100, which staff is also asking you to look at it as well. This is, again, staff makes no recommendations on this. This is up to you.
I wish you hadn't
entirely.
asked us to look at this, because I thought it was perfectly fine, because technically you can turn around a piece of literature within 2 days and have it mailed within a 7-day period and could land in people's mailboxes the day of the election. That's all technically possible. So I don't know whether we really need to tinker with the work that had already been done by a committee that was very thoughtful, that did a lot of research on this. And it is transparent, and I think transparency is what's so important here. This is what these disclosures are all about. By disclosing less, you have less transparency.
Again, staff makes no recommendation on these. These are all completely up to City Council discretion. These are being brought to you based on City Council direction previously to review and various provisions. Of
Okay, what is the threshold, 100?
For the 24-hour notice, for the 24-hour
So we could raise the...
For local.
for local, under the local ordinance.
Okay, well, I'm going to say just leave it the same.
Yeah, I'm going to move we keep it the same.
I could support that.
All right. So no
you raised some
change
good
on
points,
item
No
Madam Mayor.
changes on item 9. Please vote. And,
Councilmember Price, did you wish to vote no for no change? Motion carries 5-0.
All right, item 10 is the voluntary expenditure limit, and I'm moving that we do not enact a voluntary expenditure limit.
I would agree with that. Anybody else? No? Please vote.
Motion carries 4-1. Councilmember Price dissenting.
Need to understand this. It says here whether to amend the ordinance to include a voluntary expenditure limit.
The motion was
No.
to not enact.
To not,
To not enact.
then it is a 5-0.
Item
Motion
11.
carries 5-0.
Item 11 is the issue of personal loans, and I'm moving that we do not impose limits on personal loans by candidates.
I would agree with that. Please vote. And you want to vote yes on that one, Mr. Price?
Thank you. I think I'm catching on.
Motion carries 5-0.
Item 12 is a review of campaign report forms. This requires city staff to review campaign report forms and bank statements to verify accuracy. I'm moving that we eliminate this review by city staff.
Okay.
Just for clarification, with respect to this, the question really is whether you want to continue to require the bank statements be provided to the city.
No.
Okay.
So the motion is not to require bank statements.
Yeah, eliminate this review and not require.
Okay, and then if you are in support of that, you want to vote yes. Please vote.
Motion carries 5-0.
Okay, and before I move item 13, just a clarification. This is to require that campaign literature to cities be submitted to the city for records, and that involves both campaign committees, candidates, controlled committees, independent expenditures, all those.
Any type of committee.
All right. What is the enforcement mechanism, and what's the penalty if you don't do it?
There is none at this point.
Okay, and who would enforce it?
It would be an interested party, an
Okay.
interested person under
So
the civil,
we're-
under the general civil enforcement
All right,
provisions.
so basically, because I'm inclined to do this, but the reality is I don't want anything on there that's really non-enforceable, that has
Right,
no
right.
teeth. So
Right.
based on that, I'm going to say that we
Anything
don't
that
do
doesn't
it.
have a specific provision for enforcement in the actual subsection, we have a general enforcement provision in the ordinance itself that allows interested parties to enforce any
Yeah,
provision.
because I don't know, I don't know how you enforce it, I don't know how you compel people to do it, and I see many opportunities for honest oversight I forgot, so I'll move that we don't require this.
Okay, any questions? If you are in support of this motion to not require it, then you want to vote yes.
Motion passed, 5-0.
Thank you. Boy, that was very meaty. And I'm glad that we have several items coming back for further discussion. And I think, I'm not sure whether this needs a formal motion, but I would like to, I would like to see what we discussed tonight, the actions taken on the city's website, so the public has a chance to view what we are proposing. If anybody is in disagreement with that, please let me know. Are you okay with that? Okay, everybody? All right, good.
Mayor, we do have a council recap section that we can make very specific.
If
That's
they
listed
know
on the
to
web.
click on that, do the people know to click on that? I'd much rather have it
Very visible.
easily accessible.
Okay.
Yeah. All right. Then let's see here. This completes our study session. We don't have any speakers. Nothing left after that. And thank you all very much for this very healthy discussion, honest discussion. And I think it was good for us to talk about various things. And we will have a chance to talk about them further at a council meeting in October. And to the latter part of October, correct, Mrs. Noonan?
I'll have to meet with City Manager Mitnick to go through the calendar to figure out, but obviously it won't be next week's City Council meeting, but...
Very good. And to echo what Mr. Fox stated at the beginning of the meeting, I do feel that healthy discussions like these are good for us. The council has been working well together, and I'm glad that we were able to exchange ideas and thoughts about this particular issue, and I do appreciate the cooperation by everybody here involved, and also I'm very glad to see that we've all been working well together. So with that, I will adjourn to the next regularly scheduled meeting, which will be taking place September 24th. Until then, have a good night.